Okay, good evening. This is a regular meeting of the Princeton Zoning Board of Adjustment being held electronically via Zoom on March 25th, 2026 at 7:30 PM. Adequate notice of the time and place of this meeting has been given by prominently posting notice of this meeting on the official bulletin board at the municipal complex, by filing a copy with the clerk of Princeton on March 20th, 2026, and by posting a copy on the municipal website homepage as a public notice. That's it.
Good.
Okay, Claudia, can you call the roll, please?
Sure. Ms. Chen,
Here.
Ms. Coulson,
Here.
Mr. Floyd,
Here.
Mr. Shriver,
Here.
Mr. Tenenbaum, Mr. Stein,
Here.
Ms. Donna,
Yes.
Mr. Dobkin, Chairman Cohen.
Here.
Thank you.
Okay, we have two resolutions this evening. The first is 68 Clearview Avenue, Block 7307, Lot 12, in the R7T zone. It's case number Z25-716. I believe that was emailed to us. Karen, do you want to explain the resolution, or is it okay as it's written?
I think Clearview is fine as written. It's 344 Nassau that we need to discuss.
Oh, I'm sorry. I talked about Clearview. That's right. Okay, so Clearview was in your packets. Does anybody have any questions regarding it? Questions, comments, or motions? Anyone?
I move we approve.
Thank you. Do we have a second?
I'll second it.
Thank you. Okay, any discussion? If not, Claudia, can you call the roll, please?
Ms. Coulson,
Yes.
Mr. Shriver,
Yes.
Mr. Stein,
Yes.
Chairman Cohen.
Yes.
Thank you.
Okay, now I got a little ahead of myself. Okay, the next resolution, case number Z25-651, 344 Nassau Street, Block 32.01, Lot 214, in the AHO-2 zone. Now that, Karen, do you want to discuss the resolution?
Well, one condition, it's condition number 11. And I think everyone's in agreement that there's one marked parking space for each affordable housing unit, with the remainder of the parking spaces to be assigned by the applicant. But the second sentence in that condition, that the applicant will provide copies of written leases for offset parking spaces for its commercial tenants. The staff has raised some questions. And so I guess the question for you is, do you want to keep this condition? I know Chris Tarr and the applicant, I believe, are here tonight, and they also wanted to speak to that. So, Claudia, if you could move them over.
I see Chris Tarr on the,
Yeah,
his name on the
There's
screen.
Chris.
Good evening.
Good evening.
Chris, I think pursuant to our email today, I don't know if you had some comments on the applicant providing leases for offsite parking spaces.
Sure. Daniel's testimony at the hearing was that there are spaces available in the neighborhood. The most likely place he could park is at Bank America, 4 or 5 doors down. But to lease from them, he said, you have to pay the money right away in order to get the lease right away. This building isn't going to be modified for 2 years. So if the language here could just say that the conditioned occupancy of the commercial space on obtaining sufficient leases, for the people who are going into the space, we'd appreciate that. The staff and we both agree it's a little vague right now. It doesn't say how many spaces or when, and we just like to clarify it.
Well, how,
Right, so what does the board have a reaction on this?
just to the number of spaces for the commercial tenant. We didn't discuss the
No.
potential number of occupants.
No.
Daniel said he was going to look around for and rent to an organization that had a need for very few cars, parking. That was his testimony.
How many square feet is the commercial?
Daniel, are you on? Did Daniel get elevated?
I don't see him.
I don't see him either.
I hesitate to say I thought it was 2,000 feet to 2,500 feet.
Okay.
He said he's here. He said he's watching. Can somebody elevate him?
Let's see.
I don't see him on the
How about,
screen.
can he raise his hand?
Daniel, can you raise your hand if your name isn't on the? I can just ask him how many square feet. He's
Oh, here it is. It's iPhone 2. I see a hand raised next
yeah.
to
Could you?
iPhone 2.
Yes, thank you.
Okay.
There he is. Daniel.
You're muted. And also you're not.
There
There he
you are.
goes.
Hello, hi everybody.
Hello.
Hi. The space, if I recall, is around 2,000 square feet. My testimony at the time was we ended up landing on two of the parking spaces. One each would go to one of each of the affordables. The remaining would go to residential, with the exception of one, which would go to the commercial. I did provide some leases at the presentation that and letters of intent that I have, but my understanding was it was approved without the leases being provided as a contingency. It was just as a way of exhibiting that there are spaces in the area, and like Chris mentioned, Bank of America being the big one, where they are willing to lease spaces, but not willing to give letters of intent in advance.
I do remember that. So if we really didn't specify the number of spaces, I don't really, and we've only got effectively only one for the commercial space.
Actually, I was just going to correct you, Daniel. I believe the discussion finally ended with the board saying the one marked parking space for each affordable housing unit, and the remainder will be assigned by you as the developer.
Yeah, correct. Right.
Okay. But I'm sorry, Steve, I cut you off. You were starting
No,
to
no, no.
say.
So I'm just wondering, did we have any number of spaces assigned to the commercial?
No. No.
Okay, well, if we didn't, there's nothing that really we can do about that now, I believe. And
I agree with that, but the question, I guess, is, do you still, I think what Chris Starr suggested was that the applicant would provide copies of written leases for off-site parking spaces for commercial tenants upon occupancy, not now.
well, we talked about the potential saying before the building is occupied or the commercial space is occupied,
Correct.
he would have to produce the leases. The thing is, the leases for how many spaces? I mean, 2,000 square feet of rental space, could be 8 cars. I don't know if that's going to be necessary, but it's going to be some number.
Daniel's testimony was that he doesn't know who's going to be in there. He's looking for one significant tenant that doesn't have a lot of cars. But I think the discussion was around the fact that becomes a private matter. If he can't find enough parking spaces for a proposed tenant, the tenant's not going to rent there. But if they say we need 5, 8, he'll have to go over to Bank of America and rent 8 spaces for them.
Well, I think, unfortunately, I tend to agree with you that if he can't produce the parking, then he may not have the tenant. So, so I guess we have to say, what we're going to do.
Chairman, Mr. Chairman,
Yes,
yeah, it's Mike.
yes.
My recollection is there was actually no condition regarding having to produce leases up front for the commercial. I was actually surprised when I read that in the resolution. So that's my recollection.
Well, I think, Go ahead.
That's as far as I understood as well, is that that wouldn't be a requirement, though it would be in my interest, obviously, if
Yes.
needed, to allocate to have those spaces, some which I can already have access to, some that I would be able to have access to in the future, but that it wouldn't be specifically a resolution kind of compliance issue
That's my
or
recollection.
occupancy issue.
That's my recollection too. There was no specifying of what's in the resolution regarding.
yeah, I think you're right. You are right.
So then that will come out entirely then.
But the question is, and just as a question, you're not going to give away residential parking spaces to the commercial tenants.
That's not my intent. I think that there's going to be more of a demand for the residential units, but if enough residential units have passed on the parking spaces, then I would open up remaining spaces to commercial tenants if they're available.
Sure.
But it would be prioritized to the residential units first.
Okay. All right.
Well, let me ask the board one more question then. We would normally, indicate the bases for why variances are approved. So if the applicant is not going to have to provide offsite, or they will, if they find it necessary, the basis for the board approving the minimal onsite parking would be what?
Well, I would think, just trying to think it through, that
Well-
the applicant has basically said this is market driven. If he finds the only tenants who he can find require parking, it's his responsibility to himself to find them parking.
So
And
if we were to say that the applicant will, the board's finding is the applicant will provide offsite parking for its commercial tenants if required by the tenants, or if he deems it necessary or something like that.
Well, I mean, again, I would think, and I'd like the comments of other board members to say as necessary, because we have, I mean, I'm quite frankly not as concerned about the commercial space parking. I'm concerned about the residential parking. And, we want the housing and we want the affordable units, and the commercial space is, up to the developer. And if he can't provide parking for tenants, then the space is going to go empty. So I don't think we need to put a requirement in there. I mean, if anything, as to Mr. Barsky's statement, that residential tenants will be given preference for any vacant spaces.
Okay.
I guess my thought, Karen,
Right.
to your question, if your question, and especially if it's coming from someone else has an application for a different project, and we give a variance for less than the amount and no specification, how do we justify what we give in this application?
Well, that's pretty much what I'm asking. I mean, if you
That's
look
what I
in,
thought.
if you look in paragraph 11, in the middle of that paragraph, I have a sentence that said the board notes there'll be minimal on-site parking, but that, the approval is conditional on the applicant providing leases off-site for its commercial tenants, which was my understanding, but I see now from board comments that I may not have, I may have been relying on earlier comments. So perhaps that's why I'm trying to find a middle ground here. There is minimal on-site parking, but that, the applicant will determine if off-site parking is needed for his tenants. And if so, something like that.
Well, I guess my thought is, you can reference he has identified potential and actually produced some leases.
Correct.
So that's a step in the right direction. If there was another application, and I think the sites, the close ones, were acceptable to the board. We could word it that way. And anything more that, I don't know, that I fall back in the past, not with zoning, but with other stuff, he will endeavor to secure.
Do we want,
Okay.
Michael, do we want to say anything about the statement that he made regarding getting a signed lease this early in the process? So producing signed leases only when the space is actually available, the commercial space is available for occupancy.
Talking about that, and I thought that the conclusion was no, just take it out.
Yeah. Yeah. I can't say yes to that, Steve.
Okay.
Okay.
I can't follow.
All I'm asking about is really just
Right.
a basis. And as Michael points out, so that for future applicants, if they also say, well, I know my requirement is 25 spaces, but I only want to provide 8. And I know you proved that before, so I'm really, I'm very similar situation. So let me provide 8 spaces. So, but what about the board notes there'll be minimal on-site parking, but that the applicant has identified potential off-site parking spaces and will endeavor to secure such parking if
Right.
required by tenants. Is that acceptable to the applicant or?
Yes, surely.
Yeah,
Prior to
okay.
occupancy.
Right, prior to occupancy. Okay,
That's what I was referring to, Michael.
okay.
But
Karen,
use
2
of the
pages,
word, the use of the word endeavor is really just, we're punting, right?
Yeah, well,
Well,
Sure.
yeah, you don't want to say that on the record, Steve.
Okay.
Also on page 18, number 11 has a similar sentence just while we're cleaning.
sure. Page 18. Yes, that's what we were talking about, Chris, and we were going to take that second sentence out.
Yes, right.
Yep.
That's similar to what we're talking about on 11
Yes.
on page 16.
Yeah.
Well, thank you very much. I think that clears it up from the applicant's point of view.
Does anybody else have any
Yeah.
issues they wanted to raise?
Karen, I do.
Yes.
One. It's under the heading of use variances.
Yeah.
It's about halfway through.
Yeah.
And the last sentence says the 2 affordables will be on the ground floor.
Yeah, that's
Uh,
incorrect.
Hold
yeah.
on a minute, it shouldn't say that, just.
Yeah, only one will be on the ground level.
Right, and one's on the third, so I thought you wanted to just fix
On
that.
page 9.
Got it.
Good catch.
Thank you.
Do we want to say more specifically that it's the front unit,
Absolutely.
the 3-bedroom unit? Yeah.
It,
It's the one that's near Harrison, right? On that.
Correct.
Here's the street, yes.
Okay, got it.
So how do we do this now? Do we vote on it now?
Yes, well,
Okay.
since since on certain variances, we had different votes, I guess what we're gonna have to do is I guess what we'll have to do is go through each one. We'll say it's a roll call vote on the resolution and memorialization, and then we'll go through each set of variances and we'll have to take a roll call vote on each one. So so this is our roll call vote on the resolution and memorialization. First for the D variances. And again, only those, well, in this case, everybody who's here tonight, George was not in attendance, but everybody else voted yes, so you'll all be able to vote on this motion to memorialize. So Claudia,
Okay.
if you could do the roll call.
Karen?
Yeah.
Karen,
Yeah.
Claudia, sorry.
Mr. Shriver said voted no.
No, he
No.
didn't vote no on the D
Not
variance. He
easy.
voted no on everything else, but not on the D variance.
So we're doing just the D variance now?
We're doing the D variance and we're just going to go through this list because we have varying, many of them it was only Stephen who voted no, but we have one other one where it was Eve and Stephen.
Correct.
So let's begin with the D variances.
Okay. Ms. Chen,
Yes.
Ms. Colson,
Yes.
Mr. Floyd,
Yes.
Ms. Donna,
Yes.
Chairman Cohen.
Yes.
Did you get Mr.
Oh,
Schreiber?
Mrs. Shriver, I'm sorry.
Yeah.
Yes.
Thank you.
All right. The next, it's roll call vote to memorialize.
Karen, don't we need a motion and a second?
Yeah, we do. Yeah, we do.
Good point.
Okay, good point. All right, let's start again. So roll call vote on memorializing the D variances. Do we have a motion?
I'll move to approve.
Okay, and
second.
a second.
I'll second Steve Colson.
All right. Okay, Claudia, let's try it again.
Ms. Chen,
Yes.
Ms. Colson.
Yes.
Mr. Floyd,
Yes.
Mr. Shriver,
Yes.
Ms. Donna,
Yes.
Chairman Cohen.
Yes.
Thank
All
you.
right, do we have a motion and a second now to memorialize the side yard setback variance?
I move.
Okay.
Okay,
Second, anyone?
I'll second.
Okay.
Who is that?
That
Me.
was
Bernice.
Bernice.
Ms. Chen,
Yes.
Ms. Colson,
Yes.
Ms. Donna,
Yes.
Mr. Floyd,
Yes.
Chairman Cohen.
Yes.
All right,
Thank you.
then we have memorialization for the rear yard setback.
I'll move it.
I'll second Eve.
Ms. Chen,
Yes.
Ms. Colson,
Yes.
Ms. Donna,
Yes.
Mr. Floyd,
Yes.
Chairman Cohen.
Yes.
All right, then we have memorialization for the parking spaces.
I'll move it.
I'll second.
Okay.
Ms. Chen,
Yes.
Ms. Coulson,
yes,
Donna,
Yes.
Mr. Floyd,
yes,
Chairman Cohen.
Yes.
The memorialization for the percentage of compact parking spaces.
I'll move it.
Oh, I'll second.
Ms. Chen,
Yes,
Ms. Coulson,
yes,
Ms. Donna,
Yes.
Mr. Floyd,
Yes,
Chairman Cohen.
Yes.
And then memorialization of the parking setback.
move it.
I'll second.
Ms. Chen,
yes,
Ms. Coulson,
yes,
Ms. Donna,
Yes.
Mr. Floyd,
Yes,
Chairman Cohen.
Yes.
And then memorialization on the distance between buildings on the same lot.
I'll move it.
I'll
I'll second. Okay,
Who is that?
Bernice.
Bernice.
Oh,
Ms. Chen,
yes,
Ms. Coulson,
can I
No.
vote on?
No. Eve voted no, so she can't vote on
I
that.
I thought that was on the final site plan approval and design.
That was my mistake, Claudia, and I corrected it on my draft, but I'm sorry I didn't correct it on yours. I will.
The
So,
walkway.
yeah, Eve voted no on the variance for the distance between the buildings.
Ms. Donna,
Yes.
Mr. Floyd,
Yes,
Chairman Cohen.
yes.
Thank you.
And then we have final memorialization of the preliminary and final major site plan approval with design waiver.
I'll move it.
I'll second.
Ms. Chen,
yes,
Ms. Donna,
Yes.
Ms. Coulson,
Yes,
Mr. Floyd,
Yes,
Chairman Cohen.
Yes.
Thank you.
I think that's it.
Thank you very much.
Okay.
Thank you, everybody. Good night.
yeah.
Good night. Okay, we have 3 applications this evening, all of which we have previously heard portions of. The first one will be case number Z 25-653, 154 Prospect Avenue, block 5501, lot 16 in the R2B zone. I believe this didn't need to be noticed. Is that correct?
That's correct. It's, the board's heard this twice and it's since been carried, I think, for a couple of meetings.
Okay, who is going to speak on behalf of this applicant? Well, before we start, Ms. Grivens, Mr. Bridger, who's going to, do you have any comments you want to make on your memo?
I'll just give an update on the current application. So just to refresh your memory, the applicant appeared before. Do I need to be sworn? Sorry, Karen.
You swear from your testimony this evening will be truthful.
Yes, I do.
Thank you.
Thank you. As you will recall, the applicant appeared before the zoning board at the September 24th meeting and presented their case regarding the construction of an enclosed porch with a rooftop deck area and sauna. The applicant revised the plan based on public comments and the board comments. The original plan proposed a 425 square foot enclosed screen porch with a fireplace rooftop deck containing a 70 square foot sauna. The total proposed floor area was 495 square feet, which resulted in a FAR 33.1%. The current plan reduces the area of the enclosed porch 425 square feet. Sorry. To 404 square feet and eliminates the rooftop deck and the 70 square foot sauna. The applicant also made the following change. He lowered the height of the fireplace chimney above the second floor from approximately 15.5 feet to 3.5 feet and raised the wall on the side of the property that faces 168 Prospect from 24 inches to 48 inches. The resulting FAR has been reduced from 33.1 to 32.5%. It's a D variance, requires 5 affirmative votes to pass. And that's just an update on the application, and any questions? Otherwise, I'll hand it over to the applicant.
Board members, any questions of Mr. Bridger? Okay. Who is going to present this application from the owners?
I'll begin, Mr. Chair. Can you hear me?
Yes,
My name is Neil Yaskin. I'm an attorney with the law firm of Cullen and Dykeman here in Princeton. Although I'm not in Princeton at the moment, but here in Princeton. As noted by Derek, this is an application for a D variance for an exceedance of the FAR limit. The permitted FAR in the zone is the R2B zone, is 30%. The existing condition is 29.9%. This house, incidentally, was not built by the applicants, Mr. and Mrs. Peepsack. They purchased it from the builder. The proposed FAR is 32.5%. And as Derek noted, that requires variance testimony. We have 3 potential witnesses tonight, and 1 definite witness. Mr. Peepsack, the owner and applicant, is available. Tom Bio, the architect who testified at the October meeting, is here. And then most significantly, a licensed planner, Charles Latini, will be testifying tonight. There was a consensus at the end of the October meeting that in order to best ensure a good record and a proper decision, that planning testimony should be presented. That testimony can only be presented by a licensed planner. So unless the board wants Mr. Bio to go back and just give you a brief refresher on what is being proposed, we could move to Mr. Latini.
board members, would you like the architect to summarize where we left it?
Yeah, I
Okay.
wouldn't mind that. That'd be good. That'd be
Very
Mr.
helpful.
Okay.
Well,
I
why don't we
have-
just, why don't we swear in your witnesses for the evening, Mr. Yaskin, but everybody is muted. So gentlemen, if you could unmute, do you all swear or affirm your testimony this evening will be truthful?
I do.
Thank you. Thank you.
Aaron, I have a housekeeping question.
Yeah.
You marked into evidence at the October hearing of some of Mr. Bio's exhibits.
Yeah.
They don't need to be remarked, do they?
No.
Okay.
No, they don't.
Tom, can you appear? There you are.
He's on the screen.
Could you go back, refresh the board as to what the project looks like? And I think at the October hearing, you offered a cover sheet and then you had a drawing as well. I think those would be the 2 that would be useful to look at.
Okay, well, to reiterate, this is an application to introduce a covered area of a structure over an existing patio. The usage of the patio and the usage of this covered structure are identical. Therefore, the homeowners' entertainment purposes to be able to sit out there and enjoy the outdoors and have some shade. We always felt that a covered area is better than an umbrella area. Umbrella areas are exempt. And so we felt strongly that this application could possibly, get reviewed and approved by the zoning board of Princeton. In the first couple of hearings, we had some pushback from neighbors who had concerns, and I incorporated the points of those concerns into the second presentation, which, like Derek indicated, I brought the structure in 1 foot further from the property line. That was not mentioned. I did raise the knee walls of the interior structure so that when they're sitting down at 48 inches, they're pretty much behind a wall so that the neighbor wasn't necessarily getting direct voice from them. We also eliminated the entire usage of the rooftop and just kept it on the first floor. which in turn lowered the chimney. So its visual did get improved as well. Since that meeting, we felt we needed professional testimony, and that's why a planner was brought in, and Mr. Piepzak properly said, well, let's get an attorney and let's do this the right way. And so since then, we've just been in planning mode and discussion mode, and we are here tonight, hopefully, to re-litigate this potential benefit of putting an outdoor covered roof over an existing patio. That's really the application as I recall it. And we did have, I'll show you, these are in your packets. These are renderings that were done by us at the office to show the three-dimensional quality of this. And then, of course, you all have the architectural plans, which are made up of, I think, 6 sheets. Let me count them. Oh, no, more. 1, 2, 3, 4, yeah, something like that. 6 or 7 sheets. Does that meet your request of me, Neil?
Yes. Yeah. The only thing I wanted you to clarify was just looking at the plans before the meeting. It looks like there's 2 components to the porch. One is what we're referring to as the enclosed porch, and then next to it is an outdoor dining area. Is that correct?
That's an existing patio. We just threw a table on there to show how it would be used.
All right. No. So you answered my questions. I don't know if the board has any questions.
Board members, any questions of Mr. Bio? No, okay.
I'm available. Thank you very much. I'll mute.
So as we move on to Mr. Latini, I just want to mention that the porch has been referred to as an enclosed porch. It's only enclosed by screens. And one of the things that Derek explained at the October meeting is if there were no screens, it was just completely open and you could put your hand out under the roof, then there would have been I think it was a 112 square foot exemption from the FAR allowance. But the fact that it's going to be screened means that under your ordinance, it's considered to be an enclosed porch. Not every municipality does it that way. In lots of municipalities, a porch with a roof is not considered enclosed, but that's the interpretation here in Princeton. So if we could move on to Mr. Latini.
Good evening, everyone.
Chuck, I'm gonna, if you don't mind the informality, I'm gonna address you as Chuck.
No, not at all.
Could we begin with you stating your qualifications for the board? And by that, I mean education, experience, licensing, and prior testimony as an expert.
Sure. Good evening, Mr. Chairman and members of the board. I'm Chuck Latini. I am a licensed planning practitioner since 1997, which is basically shortly after graduating from Rutgers with a degree in environmental planning and design. I have worked since that time as a licensed professional, dues paid, continuing my license since then. I've worked in numerous municipalities across the state and testified before every board in Mercer County but for Hightstown Borough, believe it or not. I am current city planner in Bordentown City as well as township planner in Ewing, where I also serve as zoning officer as well. So
we will, I'm familiar with you and your work, and I will accept you as an expert.
Thank you, Mr. Chairman.
You're welcome.
Thank you, Mr. Chairman. Chuck, moving on to the substance of the application.
Sure.
Have you reviewed the project that is the subject of the application?
I have indeed, yes.
Have you reviewed the applicable FAR ordinance?
I have.
Have you formed an opinion as to whether the exceedance of the FAR limit meets the requirements for the granting of a use variance under Section 70 of the Municipal Land Use Law?
So I have, and if you'll allow me to explain all my research.
So exactly, I would like you in narrative fashion to explain your reasoning to the board.
Okay, thanks, Neil. So, Mr. Chairman, board, I was engaged to evaluate the proposed improvements and provide planning analysis and testimony as to this requested FAR variance. At its core, as you know, the application becomes necessary not because of a meaningful change in the use or intensity of the use, which is customary for a lot of D variances or density, but in this case, we're looking at how the ordinance defines floor area and the PSAC's desire to mitigate any potential impacts of their enjoyment of their yard. It is a D4 variance where bulk type control is tied to building form, not use intensity. So Princeton's FAR calculation includes roofed and covered areas, as you know, even those that are not usable living space. I suspect that's for reasons on how building mass may present itself within neighborhoods. And so here the proposed addition introduces walls and screening around what is effectively an already outdoor space. The architectural refinement, while improving function and aesthetics, triggers a disproportionate zoning impact because of how it's counted as floor area, even though it's not materially increasing the intensity of the single family use. So from a planning standpoint, the board, is required to focus less on the arithmetic outcome, or should focus, right, not required to, on the arithmetics and more on the actual impacts of the building form. So first, there's no change in use. This remains a single family residential property fully consistent with the zone. Obviously, as you've heard in past meetings, which I've listened to, you know that the house was originally built and maxed out the FAR. Second, there is no meaningful increase in bulk or visual impact. The improvements are located in the rear yard, architecturally integrated, and substantially reduced from the original proposal as reflected in the revised plans. Further, there's a similar structure right next door. Third, and importantly, in response to neighbors' concerns, the project represents an environmental and operational improvement, in my opinion. What was previously an open wood-burning condition at grade and an outdoor space actively used is now being replaced with a contained and cleaner gas fire feature, which reduces smoke impacts and directs any emissions upward rather than laterally across the adjoining properties. Finally, when viewed in proper context, the resulting FAR is not anomalous. So the comparative analysis I performed on similarly situated homes at Princeton's commonly falls within a same range, particularly on smaller lots. So what we're left with here is really no intensification of the use, no meaningful change in neighborhood character, a reduction of potential nuisance impacts, and a variance that's triggered largely by ordinance mechanics, not necessarily the impacts of intensification of the use. This is precisely the type of situation where the variance process is intended to be implied, and it's appropriate that you're here entertaining this. So while technically a use variance, a D variance, it is the duty of the applicant to demonstrate that the site can accommodate the problems associated with this increased floor area. So what we're going to do is approach as if it's a regular old FAR variance and not diminish it in terms of the proofs we need to put on. So a review of the surrounding neighborhood, when I looked at all the sales data, and that's immediately located on the town's website. The proposed improvement is located entirely within the rear yard and is largely screened for public view. The design is integrated, and the FAR increase does not materially alter perceived mass or neighborhood character. So when looking at the FAR analysis that I've worked on, the surrounding neighborhood demonstrates an adjusted FAR value that falls within a range of 0.2 to 0.32 range, with similarly sized parcels approaching or exceeding the proposed FAR value when evaluated on a habitable floor area basis. So how does the project stack up against our need to weigh the positive and negative criteria? So let's start with the positive, or the special reasons. The advancement of the purposes of the municipal land use law. So the special reasons for this application are grounded in the advancement of the purpose of zoning. Under Burbage case, the courts have recognized that improvements which reduce adverse impacts and enhance site functionality can constitute special reasons. Here, the proposal replaces open wood burning conditions with a controlled gas feature, reduces lateral smoke to adjoining property, and improves the usability and containment of space for the enjoyment of the Peepsack family. These are both functional and environmental improvements. To further address the special reasons, the applicant promotes purposes A, I, M of the municipal land use law, specifically A, to encourage municipal action and guide appropriate use or development of lands in the state, to promote public health, safety, and welfare. Purpose A is advanced by facilitating a reasonable residential improvement that remains consistent with the permitted use and established neighborhood character. The proposal improves the functionality and design of the existing residential property by enclosing and formalizing an already utilized outdoor space. So it makes the property better, not necessarily bigger in a meaningful way. Purpose I, which is to desire visual environment, is promoted through the architectural integration of the addition, which improves the visual environment and creates a more cohesive and contained design. The proposed improvement replaces the open wood burning condition and controlled gas feature and reducing and better directing emissions. And then lastly, purpose M is satisfied by enabling the efficient use of an already developed property where the proposed improvement enhances functionality without expanding the use, occupancy, or intensity of the site. So to put a finer point on the intensity question, under Kaufman, the court emphasized that bulk variances may be supported where the proposal does not represent a substantial intensification of use. So here, the use clearly remains solely single-family residential. The space already functions as outdoor living area. The increase is largely a function of the ordinance measurement and not necessarily activity. So it's not a case of overdevelopment, it's a refinement of the existing use. So taking that and then reconciling all of that against the Medici standard, which speaks more directly to use variances, it reinforces that boards must evaluate whether the relief advances planning purposes rather than frustrates them. In this instance, the FAR exceedance is driven by how Princeton defines covered space. So clearly we have to put on our proofs. The addition of walls and screening converts an already utilized area into something counted differently under the ordinance. The board is not being asked to approve additional density, but to recognize a technical overage that does not translate into real-world determinant. We do not have to prove particular suitability, but rather the courts have allowed a more flexible application for bulk type D4 variances. This is appropriate because the improvement is confined to the rear yard, it is buffered and screened, it fits seamlessly within the established residential pattern of the neighborhood, and it does not alter circulation, drainage, or neighborhood dynamics. When you step back from the ordinance math and look at the actual planning impacts, this application advances the purposes of zoning, improves existing conditions, and does so without increasing the intensity of the site. This is exactly the application that satisfies the positive criteria under New Jersey case law. So when viewed through the town's own calculations, this application is a modest 2.6% technical exceedance driven by how covered space is measured, not by meaningful intensity of use. So in my professional opinion, the positive criteria here are met and are clearly satisfied, and the application can be granted and considered by the board without substantial detriment to the public good or impairment to the zone plan, with the positives outweighing any negatives. So that's my testimony.
And those last two factors you mentioned, those are the negative criteria in the statute, right?
Correct.
If you could just repeat that for the board, how it complies with the negative criteria.
So when viewed on your calculations, the application is not about overdevelopment. It's the modest 2.6% technical exceedance, and the positive criteria are met as the application can be granted without substantial detriment to the public good or impairment of the zone plan, with the positives outweighing any negatives.
Thank you. Mr. Chair, that concludes our presentation.
Okay. Board members, do you have any questions of the planner? Yes, Michael.
So the big thing is is how Princeton defines the covered space, you say. How Princeton defines the covered space is not going to change.
Correct.
So I'm trying to figure out how we differentiate from similar applications that come in if they come in after this. That's a question to you.
Well, first, your application of the ordinance is to be applied on a case-by-case basis. There's no ability or no precedent you set by doing this. So in this case here, we're talking about taking a patio that's already being used, covering it, and yes, I mean, the technicality of your ordinance puts this over FAR. Our proofs, though, when you look at how they're applied, is not to a standard that's to a use variance that is typical, where the standard is even higher than what we're trying to prove. This is about a bulk standard in essence here. We're not intensifying the use of the property at all. We're actually, in my opinion, taking a space that's already being used and then putting it within a framework that the PEPSACs can ameliorate the noise, ameliorate the smoke, and enjoy their property without impacting the neighbors.
Mr. Floyd, if I can just make an offer, I think one answer to your question actually lies in your agenda for tonight. So this is a particular fact-specific and site-specific setting, which is taking an existing grade patio and putting a roof on top of it. The next application is an application to build a new home on top of an existing foundation, but it requires exceptions because of a side yard setback and a height to setback ratio. And then the third one actually involves variances for an addition to an existing dwelling. Neither of these are analogous to what you are hearing tonight. This is a very specific situation, which is just taking an open on-grade patio and putting a roof over it.
So what's the point? I mean, each application is reviewed individually. The other two are site-specific and will be reviewed in context.
Well, I think I could walk outside my door and I have a patio, probably about the same size. And I meet all the setbacks, so I could do the same thing. And I assume I'm probably at the FAR max. So I'll just say that, and I imagine there's a number of people on my screen right now that probably have a patio.
Yeah, and then, but if I may, Mr. Floyd, if you were to do that, it'd be your right to bring it to the board and design it with the intentions that the PEPSACs have done, and for your consideration, of course, and to weigh those against not doing it. So here we have something that has been thoughtfully designed and presented in a way with real intention, right? This wasn't just throw a roof on it, let's call it a day, hell, my neighbors. This is really looking at what are we doing? How are we doing it so that we don't have to hear anybody? Because they're busy people. They don't want to impact their neighbors. They don't want their neighbors having to complain about them or anything else like that. So here we got a thoughtful design being presented, and being presented in a way I think warrants your consideration.
Yes, thank you.
I have a question, Steve.
Stephen.
You all may not be able to answer this or respond to it, but several years ago, one of your neighbors in the backyard requested a variance to build a larger addition to their home. And at the time of that, the neighbor to the right, if you're facing your house, complained about water runoff from the neighbors back there. Now, I can't remember. I don't think you guys were under construction at the time, but you might have been, but I don't remember. You didn't come before the board because you didn't need any variances. But I'm wondering, is there any water issues back there? Is there any water runoff issues going on now?
May I answer?
Yes,
Sure.
Mr. Pizak.
I believe I was sweared in. I hope that still
You were.
continues.
You were.
The answer is no, none whatsoever.
Okay, thank you.
And to put a finer point on that, Mr. Schreiber, here we're building over an existing patio, so that patio is impervious today, and so there's no increase of that area. So any runoff, it would be the same amount of runoff.
But effectively, you're building another room on the house. And the FAR, when the property was developed to the max, as I assume was the one next door. And the justification for that, I question. And as Mr. Floyd said, again, that could happen all throughout the community. And how do we rationalize this in a house that was new and built to the maximum and now modified to exceed it?
Other than, I'm trying to think of a way to respond, other than falling back to Mr. Latini's testimony, which takes this application and puts it in the context of the municipal land use law. I think that's the answer at the end of the day. You characterize this as effectively you're building another room. We disagree. This is, by any measure, this is not another room. It's not an enclosed, heated, air-conditioned space. It's probably not wise for lawyers to make personal observations, but I live in Lawrenceville, and some years ago, after living in this house for about 20 years, we now have lived here 35, but about 15 years ago, we put a screened-in porch on a portion of our rear deck. It allows us to use that outdoor space when it's raining. It's more comfortable when it's hot, and we're all experiencing the phenomenon of temperature increases. So it improves the livability of a lot of homes. And, turning back to what Mr. Floyd was saying, other people may say that's a good idea. Now, on smaller lots in Princeton, when somebody wants to take an open patio like our clients have and put a roof over it, that triggers this requirement. But that requirement, in a way, is elevating form over substance. We're not criticizing the ordinance. The ordinance is the ordinance.
Right.
Mr. Latini's testimony explains why the application meets the purposes of the ordinance.
On his interpretation, it meets the purposes of the ordinance.
Well, no, my interpretation is that it doesn't meet the ordinance. Your standard here is about the character of which this is being exceeding. It's not an intensification of the use of the property. If this was a fully enclosed in heated air conditioned addition to the house to put another bedroom in here, absolutely intensification, right? Here it's not. Here the standard is just a teach bit lower. Obviously, you have neighborhood impacts to consider. You got design impacts to consider. You got effects that you want to ameliorate, through any condition that you might put on the application. But you're really looking at, the design character versus anything else. I'm not criticizing the ordinance at all. I understand it being working for college towns in particular, trying to control that, because every developer will do exactly what this guy did when he built this house, which was maximize the FAR because they want to get as big a house as they can. Here it just it sort of backfires on the next resident, because if they want to do anything to make it their home and to utilize the space a little bit differently, then the ordinance kind of keeps them confined, and that. Again, that was the purpose of your zoning, is to keep that confinement in place so that you do have to prove why you're going to do what you're going to do in exceedance of what we've already found is our standard. So, here I think we have a case to be made about creating this seasonal space that the Peepsacks can enjoy. I mean, they can do everything that they want to do in that space. They can do it outdoors right now. And they do with a smoked fireplace, and which I would add, creates more of a nuisance to neighbors. And certainly when you bring your TV outside and you watch a game outside, there's no attenuation of sound. There's no you could put a tarp over that, and or umbrellas, and use that space with sound and smoke and everything else going on. Here,
well, the fact that it's wood or gas is you could have an open fireplace side. They could be a freestanding fireplace that's gas fired.
It could, but it's not a requirement.
No, I know, but to make that an argument, it's separate and aside from the fact that this is still a room.
Yeah, no, I understand that, but it also is, again, goes to the total package. The design intention is to reduce smoke, to get it up above the height of the thing. So it is to be weighed a little bit, because it is an intention of the design feature.
Mm-hmm. Okay.
I have a question for Mr. Lucchini. Mr. Lucchini, you testified about screening and buffering, that there's both buffering and screening in this plan. So what do you consider buffering and screening?
Well, to me, the buffering and screening is done through the changes they made, which steps it back off of the side edge of the building, so it reduces the impact. So in some cases, you have that side view is reduced because it's screened by the principal structure itself, and then the landscaping that's on the property currently. If you wanted further additional landscaping, which I believe Peepsacks have evergreens running down the whole side of the property, that could be a consideration, but I think it's fairly well screened from public view.
I thought that actually it was literal screening, that it's a screened in area, right?
I think there were two questions. The word use of the word screening was a little misleading.
Oh, yeah.
Well, but to respond further to Ms. Deanna's question, the home to the right, when you're looking from Prospect Avenue, the home to the right, which also has a roofed-in porch, they installed a fairly robust fence, and then the Peepsacks planted a lot of evergreens on their side of the fence. So not only are you getting visual screening, you're getting buffering between uses. Particularly plants like that give you some sound attenuation. So I think that that's what he was referring to.
Yes. Thank you, Neil.
So now the water, when it rains, would hit the roof instead of the patio on the ground. Does that alter drainage on the property at all?
It's really a question for an engineer. It doesn't increase the impervious cover. We know that.
Yeah, water's running off of it today. I'm trying to see if there's Tom, do you have any, how's the downspouts handled here?
Yes, we're going to control the water that comes off the roof. We don't want it going onto the patio and splashing. So we're going to have a gutter system, and we're going to integrate that gutter into the existing stormwater system that is on the house.
So presumably that's taking it to the front.
Yes, probably. I don't know where those pipes lead.
Okay. So that'll actually that being the case, Tom, I think that makes the runoff, improves the runoff conditions.
It reduces the runoff.
Yeah, because right now it just stays, it runs off the patio and into the yard.
Yeah, I would agree with that comment.
Question.
Yes.
What is the ceiling height in?
I couldn't understand that.
Yeah, something's going on with the volume.
I only have one mic. What is the ceiling height inside the porch? Is it around 10.6 or so?
I'll answer that. Just give me a second.
Mm-hmm.
10 feet. It's 10 foot even.
10 even.
Board members, any other questions?
No, I'd like to hear what the public, if there's anyone, has to say.
We'll go to that after this. I guess I'm still questioning the increase in the FAR over the maximum. I mean, I understand that you've made a case for a room that's and it is a room that's been designed and integrated into the overall property, but it still is in excess of the FAR.
Let me respond by asking. Let me ask Mr. Latini a question. Let me respond to that. Chuck, the case law and the municipal land use law distinguishes between the perfect and the good, and that's one of the reasons that we have variance provisions. So could you address Mr. Cohen's concern in that context?
Can you ask the question again?
Yeah, you actually were telling me, you were explaining to me that, hang on, let me find it, my notes. You talked about the purposes of having variance provisions in the MLUL and granting variances from all kinds of conditions, including FAR. So, I mean, Mr. Cohen, honestly, I take your comment to mean if we're never going to entertain a D4 variance for FAR. Is that what you were suggesting?
No, not at all. In this case, I'm just wondering, again, it's a new house. It was built to the maximum. It's in an area where the houses around it are governed the same way.
It's a full-size lot. There's no topographical problems. It's a perfect lot. There's no hardship on this lot.
This is not a hardship argument.
I know.
Yeah, this is the municipal land use law, and the cases distinguish between hardship arguments and overall benefit arguments.
Right.
Yes, this house was maxed out, not by our client, It was your zoning.
Oh,
allowed
absolutely.
it. So
I
now
don't
you're
think
telling,
there's-
yeah, so
I
now
don't
you're,
think there's any use in debating it anymore. You have your position. I accept it. It's respectful. And quite
Well,
honestly, Chair, I'm not sure why I ask that many more questions. They've made their presentation.
but I think you owe me the opportunity to respond to your comment. Basically, what you're telling somebody is a resident of Princeton that they can't use their house the way that they would really enjoy it because the person who built the house maxed it out. This is, I think you would agree, this is not a mega mansion. This is they maxed out the impervious cover in the
sorry.
FAR.
What's a mega mansion?
A mega mansion is the houses we all seeing be built with huge footprints and huge numbers of bedrooms. All these people
that maxed us out and didn't need any variances, just
right.
like this one.
And all these people want to do
Understood.
is be able to enhance the enjoyment of their home. That's all they want to do. They want to take right now, if it rains, they have to come inside.
Again, I understand that. That's all they want to do. I do understand.
That's all they want to do.
Yep.
I mean, the fact that someone else built it is irrelevant. I mean, it was a new house when they bought it and it was maxed out. And the architect, as well as, you and the planner testified to the fact it was built to the maximum FAR. That didn't change after they bought the house. That was the condition when the house was purchased.
Is this an appropriate time for me to comment, or do we wait for our?
No, please, if you have a comment, make it.
I think most people would be surprised to find out that their patio was going to end up being called a room if they put some walls up and a roof over it, frankly.
Well, I mean, that's a room.
Okay.
So if I can just add a little bit here, FAR is really a tool used to approximate a relationship between the bulk of a building and a lot size. It's not a perfect measure, but it's certainly a measure that's used to keep some consistency of character and intensity of development across an entire town. So in this case, if we were dealing with a lot, even a lot next door, I didn't do the analysis, but it goes another 20 something feet beyond that. So they would technically be allowed, if this building lot was just a little bit bigger, and it's relatively undersized compared to some of the others, we wouldn't be dealing with this at all. So, looking at this covered or semi-enclosed space, as it's evolved into this proposal, really our job is to look at how it's designed. Is it hurting the intent of the zone plan? And in my opinion, it's not. It's advancing those purposes of the municipal land use law that we spoke about earlier, by advancing a reasonable improvement, and looking at how, it's designed to effectuate that visual environment and not impair it. So through good civic design and arrangement, I think, we've got something here that I think works. I mean, obviously, everybody's got their own opinion about it, but I do think you're well within your bounds here as a board to really give this a good look.
We function to, I don't know how to phrase this, but effectively, the ordinance requires on this specific lot has a maximum floor area ratio. This house was built to that maximum. And I can understand, your argument that, to fully appreciate and enjoy the house, they want this room. But the house was already built to the max.
Mr. Chair, with all respect, you keep referring to this porch as a room. If this board, since we need a supermajority tonight, if this board is prepared to deny this application, the idea that this is a room, before you do that, I would ask both your zoning officer and your attorney to opine on whether this space constitutes a room.
Okay, it's, in my opinion, it's a space with walls and a roof. And there's openings in it, but it's an enclosed space. I'd like to hear from our zoning officer and our attorney.
I would also just like to say that I think we're in the gray area zone in a sense. If it were that clear cut, I would ask why are we talking about it? I mean, I think if there wasn't a question, maybe this isn't the main question, but if there wasn't a question as to whether or not this was possible to approve, then I don't think we'd be hearing it to begin with.
Our zoning officer made a determination that this is a space that's included in floor area based on the ordinance.
So why
We
are
don't-
so
we
why are we
agree.
discussing it?
Yeah. Steve, you understand their position. They understand yours.
Mm-hmm.
I think it's time to move on.
Okay.
And we can talk about it ourselves in executive session
Okay.
and make our decision.
Okay. Do you want to present anything else right now? Or should we open this up to public comment?
No,
And
we
then
have nothing further.
Okay. All right. What we'll do is, and if the board has no other questions, you can sum up and then we'll open this up to the public if you'd like to say anything prior to us doing that.
Do you want me to sum up after the public has spoken?
Well,
or
you'll have an
before?
opportunity to sum up.
Yeah, I will.
after
Yeah,
as
that's
well.
fine. No, that's fine.
Didn't we ask, are we backing off from that? Didn't we ask our attorney and zoning officer to say something, or do
Well,
we?
we could do
No, I
that.
asked.
We could do that.
You're right, you did. Sorry.
We could do that in
Okay,
our executive session.
I just didn't want that to get lost if
It won't.
we were prepared to hear that.
Okay. All right. So you're saying there's no need to sum up right now.
That's correct.
Okay. So at this point, we're going to open this up to the public. If there's anyone in the public who'd like to speak on behalf of this application, indicate that by pressing on the button at the bottom of the screen, the raise your hands button. You'll be recognized and you can speak. Claudia, do we have anyone?
We do.
Yes.
Yes, they're at the top of the screen, Steve.
Okay.
The Koenigs and the Mrs. Polinsky.
Yes.
Okay. Well,
Hi.
So let's see. We'll just
we-
swear you in. I know you've testified before, Mr. Koenig. Do you swear or affirm your testimony this evening will be truthful?
Yes, I do.
And could you just confirm your address for us if you're comfortable giving us that information?
The address is 168 Prospect Avenue in
All right.
Princeton.
Thank you very much.
okay.
Yes, we've heard a lot, so we will have to reply with a lot. First of all, the attorney keeps on speaking about just screens and comparing it to our screen patio. Our screen patio is indeed a roof and only screens. No wall, no fireplace, no nothing. Second thing is that the architect mentioned in the beginning the renderings. And someone on the board asked for the ceiling height. What the renderings do not show is that the house already sits, I think, 3 or 4 or 5 feet above grade level, which will put the room much higher as compared to other houses in the neighborhood that are much closer built to grade level. So the fact, intensity of use, and I'm not an architect, I am just some lay person who lives there. But if you build a room without windows, because that is what you plan to build, an extra room where you can put in windows, where there will be a fireplace, and where, as mentioned previously, very often there will be a TV on the back wall. Saying that that will not increase the intensity of use of that area seems incorrect, because if you want to watch TV in the afternoon, you can now sit in your house, on your patio. Previously, you would have to watch it in-house. If there is a TV on the back wall, the lots are not that big. We will be able to enjoy or not enjoy what they are watching if we are outside. So I don't think that you can say that there will be no nuisance for the neighbors. Also, there will be a big visual impact where we could look now to the side and look at the sky, so to speak. We will now look at the back wall with a chimney for the fireplace. Will be a very different look. Also, the wood burning conditions. It will be used much more because there is a roof over it and because there are walls that will keep the warmth inside. So saying that it's just nice for the people and the visual impact from the street will be very, very small. I agree with that. But for the neighbors who are using their backyard, it will be a nuisance. That's all I can say. And I think, I don't know whether my husband has something to add to that.
Do you want me to swear in again?
Oh, no, you're fine. You're fine, Mr. Koenig.
Okay, good. I have very little to add to that. Most of the arguments have been made before. I'd like to repeat or emphasize 2 small things before I would like to ask Erik Holterman, our architect, to give his professional comments. The first thing is that in terms of impact on the neighborhood, a house is not just a floor ratio, it's a 3-dimensional thing in height. And the fact that the ground floor is built at about 4 to 5 feet above grade actually amplifies the height impact of the proposed addition. The second thing is that, as Chairman Cohen already mentioned, the fact that the house was built by the builder, not by the Piepzak, that's absolutely true, but by the builder to the full maximum in all dimension allowable, makes it very, very hard to swallow a precedent of exceeding that again by another 3%. So Erik Holterman, our architect, I think would like to make comments, but other neighbors like Areta Pawlinski can add to that as well.
Okay.
Mr. Koenig, did you say your architect is going to speak to this, or you're asking the applicant's architect?
Either.
Is your architect here tonight?
He is actually called into the Zoom. You don't see his name is Erik Holterman.
I don't see Mr. Halter. Oh, wait, is that HMR Architects?
Yeah, HMR Architects, yeah.
Okay, okay, I see him. His hand is raised in attendees. Buddy, can you move him over?
Or otherwise, Aretha may be able to continue and Erik can join afterwards.
He's muted and we obviously would like to see him.
All right, well, let's go on maybe to Ms.
Okay,
Pol-
I'm
Oh, here he is.
I'm here now.
Okay, okay.
Thank you
Mr.
very much.
Holterman, I'll just swear you in again. I know you were sworn in previously. Do you swear affirm your testimony this evening will be truthful?
I do.
Thank you.
I'd like to make 3 points. The first is that there is, of course, the obvious issue of dealing with a D-variance where the developer built a house to the maximum FAR, and then how that's dealt with at a later time when people come back wanting to modify the house. Apparently in this case where they're unable to shed any floor area somewhere else in order to be able to comply. We haven't heard anything about anything like that. I'm not an expert on this house, but I am an expert on the house next door at 168. That house is actually well below the 30% FAR. It's still a generous house, but 30% FAR in this neighborhood on these lots is actually allows for a fairly generous house. Also, I would say that I scaled the architectural plans for the addition here. There are no vertical dimensions on the plans for the new addition, but just by scaling them, it looks to be like the top of the roof of the addition would be something like 13 to 14 feet above the ground. And Mr. Bayo can clarify that if he has good information. But from the plans, that's what it looked like. Second point I wanted to make is that there was mention made of the porch behind number 168. As Vera Koenig said, that porch really is quite dissimilar than what's proposed here. That porch really is a couple of columns and a roof. The screens completely roll up into the roof so that most of the year there aren't even any screens. And it's only a screen porch when the screens are activated and roll down to the floor. Otherwise, you actually see right through it. It doesn't have any walls. Most of the time the screens are up, you actually look right past it. It's really quite minimal. In terms of a detriment to the public good, I just want to mention the design of the proposed addition at 164. If you wanted to design something in a way that would maximize the sound going out to the sides to your neighbors, you would design it exactly this way, where you build a parallel wall behind the house, put a noisy thing like a TV on that wall, blast the noise towards the back of the house. And I'm not saying that this applicant would ever play anything loud, but sometimes it happens. Anyway, blast the noise towards the back of the house. There's nowhere for the sound to go except out the sides of this porch, which doesn't have windows, doesn't have any really solid buffering to prevent the sound from traveling sideways because the sound can't go into the backyard. I think that those are the 3 points I wanted to make. Thank you. Thank you very much.
Thank you. Okay, do you have any other comments?
No.
Okay, no, as well as your clients. Okay, you're finished making your comments. Not you, Mr. Haldeman, your clients.
Frank and Vera, you're muted.
Sorry, no, we don't have anything additional to add right now. Maybe we can listen to Aretha.
Okay, thank you. All right, Claudia, I see another hand raised.
Great. Ms. Polinsky, could you, if you're comfortable, could you give us your address, please?
Yes, 170 Prospect Avenue, 2 doors down from the proposed.
Alrighty, and do you swear or affirm any testimony you give this evening will be truthful?
I do.
Thank you.
So this is the 3rd time that I'm speaking out, and I am reiterating my objection to granting the additional square footage. Both my husband and I have already stated our objections in September and in October. There are some very good points being made today, and Mr. Cohn's question of how do you justify this? You cannot justify this. The question about finding livability, improving livability, how can two people not find livability in 4,600 square feet? The previous meeting, the aggressive nature, nearly threatening voice about smoke and what's entitled to sending smoke was just hard to believe. So today's focus by the planner and the attorney about benefits in public health, safety, and welfare by reducing the smoke that doesn't need to be there in the first place. It's hard to accept this as a valid argument. The question about changing the neighborhood character, that this does not change the neighborhood character, I beg to differ. I have lived in this home for 11 years, and we have watched the neighborhood change. If I can, previously we showed how 164 Prospect exceeds the neighboring houses in both height and mass. And we showed those pictures on screen. The discussion about the fact that it was built by a builder, yes, that same builder built the mirror image of this home 4 or 5 blocks further east. That could have been seen what the impact was. But I would like to show you another way how the character has changed, if I could share my screen.
Sure.
Is that okay?
Yes, it is.
So on the left,
Before you proceed, Karen, could these be marked, please?
we will mark this as objector. Ms. Polinsky? I don't remember if we marked your previous documents. I think we probably did. But we'll just call this objector exhibit with the date, because I'm not sure what number we're up to. So that would be March 26, 2026. And let me ask you, you took these photos yourself? Is that correct?
Yes.
Okay. All right.
I'm just trying to give you a flavor for how the neighborhood has changed by the construction that was built there. So on the left, this was taken before the demolition of the previous house happened, and on the right afterwards. So you see 3 very large mature trees at the property line that were acting as screens that came down in the process. Now I understand that the current owners were not responsible for those trees coming down, but we as neighbors are seeing the shift, and it is not a positive one. In September, we spoke about the number of cars in the front driveway on this narrow lot that often were about 5. The only house in the neighborhood that then had cars lining from the sidewalk to the 2-car garage, which maybe had 2 more. So I appreciate that after we raised that, there seemed to be a little sensitivity to where 5 came down to 3 or 2, but it has been a large change in context. So when you say there's no meaningful change in the neighborhood character, I disagree. And the points, in addition to A, which was cited as public health, safety, and welfare, I, desired visual environment, M, efficient use of existing property. These are choices made for an individual's private benefit. There is no public benefit here, and therefore I don't believe it should be granted. Thank you for the opportunity to speak on this.
You're welcome. You can take your screen down. Thank you. All right, Claudia, is there anyone else who's indicated they'd like to speak on behalf of this application?
There are no more hands.
Okay, so at this point, we'll close the public portion of the hearing. And again, the attorney can sum up before we go into executive session.
So I don't think a summation is necessary. I think we've kind of beat a lot of these issues to death, but I do want to clarify and respond to one thing that the last neighbor said, which was that this is all about private benefit and not about public benefit. When homes are improved, consistent with an ordinance or through the need for a variance, it's always for the benefit of the homeowner, always. The standard in the municipal land use law is not whether there's a commensurate benefit to the public health, safety, and welfare. The negative criteria talks about the fact that there has to be no substantial detriment to the public good. And back in October, when Ms. Polinsky testified, she showed a picture of this house from the street. And her argument was, look how this house, which my clients were not responsible for building, look how it's out of character with the adjoining properties because it's taller. And I would add that that includes the house to the right, 168, the newly built house. The fact of the matter is you can't see this proposed porch from Prospect Avenue. You can't see it. So while neighbors who live close by or abutting certainly have an interest in seeing and a concern about how a house is built, the notion that there's the neighborhood character is changing in part because trees are gone, trees that my client did not tear down. That's just not cognizable under the municipal land use law. It's just not. Again, personalizing my experience, we had two 100-year-old hickory trees in the back of our yard. They're gone because of a storm. Trees come and trees go. Those trees, which I noticed were pines, are relatively short-lived anyway. 30, 40 years from now, there'll be trees again. That's not cognizable under the municipal land use law or under this case. Princeton has a tree ordinance. Princeton allowed those trees to be removed. You can't penalize my client for that. Other than that, my only question, Mr. Chair, if you're going into executive session, I'd like to hear from your attorney on the basis for executive session.
Neil, when they say executive session, the board doesn't mean closed session.
Okay,
They just
that's
mean now
fine.
they're going to discuss it and they've closed public comment.
Okay,
So
that's
that's
fine.
why you were asked, you want to make any summation, because once they start discussing it, they're going to
No,
say
that's
no more
fine.
comment.
I understand, and I don't think a further summation is necessary. But thank you for the opportunity.
You're welcome. Okay, board. Let's discuss it. Do we want to hear from Mr. Bridger or Ms. Gibbons first about the determination on this?
Sure.
Okay.
Yeah.
Okay, so either Derek or Taylor, can you explain the determination on this that you made on this space?
Yes, it's really dependent upon the definition of FAR. It's not an open porch. Porches are exempt from FAR when there's one side open. This is a screen porch, made a determination that that's an enclosed porch. Whether it's a room or not, we don't have a definition of a room, but it would follow up almost under the habitable room definition, a living room or enclosed floor space within a dwelling unit. But I don't really see the relevance of whether it's FAR. It's clearly FAR, the way we've interpreted whether, and that's been consistent. If it didn't have the screens, then they could get the exemption for the part of the open porch, but there's still not enough area there to give them enough to do what they want to do. So.
Okay. Board members, are you comfortable with that?
Yes.
Okay, so let's discuss it. Questions, comments, motions? Yes.
I'll comment. So in terms of the additional FAR, I can understand the argument that it's not necessarily an intensification of the use of the space, since it is outdoor space that is currently being used. The issue to me is more about the bulk of the built structure. It seems like if that is noticeable to the neighbors, the vertical element, it seems like it is actually quite tall. The fact that the house is elevated and then the porch is kind of meeting that elevation. So it's not actually the additional enclosed floor area that I think is problematic. It's kind of the volume of it, and I'm not trying to redesign it, but to me it seems like if it were if it sat lower, if overall it were lower, the additional floor area I don't think is problematic in terms of increasing overdevelopment and increasing density or intensity.
The answer. I don't think the answer is no, I think. Because it's only one piece. What are your thoughts?
Who's speaking? Mr.
Speaking, I don't.
The applicant should mute.
Oh, I'm sorry.
Okay.
I think my comment, Chair, and it somewhat related to that. Obviously, I worry that what's being asked does impair the purpose of the zone plan and the ordinance because it was built to the max. There was a comment earlier that if somehow this lot got a little bit bigger, it could be done and it would be permitted and no one would know the difference. But the likelihood is that if this lot was bigger, the developer would have built it to the max and we'd be in the same spot. So I think that's how it impairs the zone, because it's a new house. There's nothing wrong with the lot, or it just got built to the max. That's all I'm going to say.
Thank you.
Derek, do you know when the house was built?
Yes.
Yeah.
The zoning permit was approved in April of 2021. So it was built in 2021.
Okay.
Board members, any other comments?
Yeah, I think that what they're proposing will be an intensification of the use, and that's actually why they're doing this, so they can use the patio for watching TV, so they can use the patio for sitting around a gas fireplace, so they can use the patio in the rain.
Okay, thank you.
Oh.
Any other comments, questions? I agree with Mr. Bridges' interpretation. And again, I agree with Mr. Floyd's comments. This is a new house and it was built to the maximum. That's the way it was when they purchased it. So, all right, does someone, if there are no other comments, does someone want to make a motion?
Let me just ask one question.
Sure.
As the applicants pointed out, this is not a request for a hardship variance. So we're talking about the C2, I'm sorry, we're talking about an FAR variance.
Mhm.
So since we're getting ready for a motion, I'm going to assume that the moving party, or I'm going to ask, is the moving party going to agree with what I'm saying now? That the board's concern is that this floor area ratio variance, although the applicant has indicated it's approximately 2.5% over the maximum FAR. From the board's perspective, in fact, it is going to cause a substantial detriment to the adjacent neighbors, and that it will also impair the zone plan, because in fact the house is a relatively new house. It was built approximately 5 years ago, and at that time it was built out to the maximum of the floor area ratio. And although, as I understand it, the board is not blaming the applicant for that. It was built legally within the zone requirements, but that having been built out to those standards, and Derek, if I'm right, the standards haven't changed, correct?
No,
Okay,
there's been changes to the attic definition, but it wouldn't affect this property.
okay. So that since all these ordinances have remained in place, your position is, in fact, it is causing a detriment. Am I summarizing how the board feels correctly? And is there anything anybody would like to add?
Well, we haven't voted on it yet.
I know that, but somebody's calling for a motion. So
Yeah.
I don't know which way the motion's going to go, but
It's hard to ignore when neighbors feel really, affected by someone who's close. And, there's obviously a whole range of how troublesome somebody's neighbor could actually be, given the opportunity. It might not, so there's, I guess the thing that I am going back to is that it does not seem unreasonable to me to have a roof and screens. That makes sense to me. And I do think that nobody would move into a house that had a patio and imagine that it would end up being considered a room. Now, that's what our zoning says right now, but I'm just, I don't, this is not, this is not leading to a clear motion on my part. I'm just having a problem with, in some ways, us being so strict about how, I think that if it were clear cut, we wouldn't be talking about it. It is a gray area. And I feel like we've been a little bit quick to be saying, well, but it's a room, so forget it. I don't know how to get beyond where I am right now, and I think I'm potentially in the minority, but
No, I agree with you that it's not that black and white.
But it's not just a porch. It's got partial walls. And it's in a sense meant to be used further into the season than a screen porch would be used. And again, going back to our zoning officer's determination, it should be counted as floor area.
Could I know that the record's closed, but Karen, could I respond to what the chairman just said?
Chair.
Yes,
all right?
you can.
Thank you, Mr. Chairman. You said it's intended to go beyond what a screened-in porch is used for. It's a screened-in porch, and nothing. The only reason there's a wall at all was to buffer the neighbor to the left. There's a 24-inch, what was originally proposed as a 24-inch knee wall that was raised to 48 inches in response to concern from the neighbor. That's the only wall. There are no other walls. It's a screened-in porch, just like the neighbors to the right. Now, I hear the argument, but there's a TV and there's a fireplace, and that changes it to some other animal. We don't agree. There are no walls other than that knee wall. I just want the record to be clear on that.
Fine.
Karen.
Yep.
To go back to your question.
Yep.
Excuse me. Yeah, I agree with how you set it forth on that representing how I feel or what my take is. I think Karen had asked the board a question. So I, for one, say yes. That's acceptable to me.
I mean, Eve pointed out that you haven't taken a vote, and that's absolutely correct. So it's hard. We can't know until we have a motion. How many? There's a motion to approve, and how many people will support that? So.
Before we get there, I have a quick question, Mr. Latini. I thought I heard you say that you were putting in a gas fireplace. Is that true, or is it a wood burning fireplace?
Gas.
Yes, what?
It's a gas fireplace.
Okay, thank you.
Sure.
I just want to, I have to kind of disagree with Mr. Yaskin. There is a wall, knee wall, whatever you want to call it, certainly on two sides. On the other side, there's a wall that encloses a chimney. So there are, substantial amount of wall type.
Ms. Deanna, there's only a knee wall on one side. Looking at the property, it's on the left side, not the right. If the knee wall is what's troubling you, it can be removed from the application. It was put in there because of the board's concern about the neighbor, because that house is built quite close to the lot line, the house next door.
Mr. Yaskin, I'm looking at the three renderings that we were given, and there's a wall on both sides, on two sides.
Would it be helpful if we could share that screen? And who can share that? Let's see.
I don't have a digital file, but I will respond that the wall on the left at the
Well, no,
patio.
wait, no, Mr. Bam, hold on a minute, because I mean, that phrase wall's been used. And so it's important for everybody to be looking at that rendering when we're talking about walls. So,
Karen, I'll share my
Claudia,
screen.
can you open that up? Do you?
I think Taylor has it.
Okay. Okay. So now we have this, now you have it in front of you.
Okay.
Is
so-
that a wall to the right as we're looking at that?
Yes, it always had a 24-inch knee wall. We raised the one facing the adjacent neighbor to 48. So, you know, both of these can come down right to the ground, but we've always had a 24-inch knee wall. The one on the right is the one we raised.
Well, then I apologize to the board. I misspoke. I apologize. Tom, can you remove those? Can you remove those knee walls?
Yes. The only reason from the very beginning I had knee walls is because if you have a dog or you have a cat, or sometimes you get this sag in the bottom of a screen over time because of the weight. So it's always better to have a little bit of a wall, and you have electrical outlets that you can plug in.
But you could put a railing in that would do the same thing.
Probably. I only heard one concern if we were to turn the building 90 degrees and literally put a full wall around the fireplace, and again facing the neighboring property. That's something that could be done. That would shield the sound, the light, everything, and it would just be a solid wall.
I don't think this is the time to redesign it during an executive session like this. If you wanted to delay it and come in with an alternative scheme, that's one thing.
That's up to my client, and I'm looking to see if he has reached out to me. Do you want to entertain that, Rich?
Yeah, I'd be willing to do that. And I also have to state for the record, if I'm not mistaken, 36 of these neighbors were noticed. Of all the neighbors that I've spoken to, 4 to 6 of them, and the ones immediately to the other side of me. So if you're looking at the house to the left, he is a doctor and she's a lawyer, and they are approving the project. They are in favor of it. So the only 2 objectors are present today, and I am listening to them wholeheartedly and am willing to redesign again at my cost to make this acceptable to these 2 concerned neighbors. And I want to be a good neighbor, so I'm willing to do that.
I think before you send it back for a redesign, we ought to have a better feel for whether the FAR is the question. And if people aren't going to agree with the FAR, it isn't going to make any difference how you redesign it.
Let me just ask
Right.
you, if the walls were removed, the fireplace wall stayed and the side walls were removed, would that be a porch, Mr. Bridger?
Yeah, I mean,
Yeah.
it's a porch. Whether, I mean, I don't know if it makes sense to have the neighbors and the applicant discuss this. I mean, that's something I hope would happen before. This is the 3rd or 4th time we're looking at this, but
Well,
There was a lengthy colloquy on October 22nd about the fact that it's the screens that make this a feature that's subject to FAR. So, stop talking porch, not porch. Derek said it's subject to the FAR ordinance. We accept that it's subject to the FAR ordinance. We're not contesting that.
Just a question.
If I may, I
If,
think the
if
distinction.
glass were added, I think this question came up at a prior hearing. Might that not lessen any impacts on the neighbors? They're concerned about the TV. So I just wonder.
I'll let my client speak to that, but from my perspective, that makes it a room. I mean, first of all, it defeats the purpose. It's no longer an open air porch that you can enjoy. It's not a screened in porch. If you put glass in it, it's a room.
Well, what makes it a room, I guess, is whatever our ordinance definition says. But I'm talking about in terms of this application. So I'm just throwing the question out. That.
But I think they wanted it to be an outdoor space, not a glassed-in space. Whether it's by ordinance considered a room or not is separate. I mean, I don't think that was the goal. Was not to glass it in or put walls up either.
That's correct.
Okay, board members, what's your pleasure at this point?
Neil, should we consider an adjournment and allow me to do a redesign?
It's not up to us. It's up to the board. I mean, we can request an adjournment.
I don't have a way of talking to you, so I'm sorry.
But we can request an adjournment, but Mr. Schreiber said if the FAR issue doesn't go away, there's no reason, no point. The suggestion being that the board's prepared to deny it based on FAR concerns.
Well,
for me, I could support the FAR if there was something in the redesign that that could address some of the concerns about the intrusiveness from the neighbors.
We don't control that process. We don't control that process. We're willing, my client indicated, we're willing to an adjournment if the board is prepared to grant one.
what's the board's pleasure?
Well, if you're requesting one, unless other board members don't want to do that, I see no reason not to allow them to redesign.
We are requesting one.
Okay. Board members, am I erring on the side of allowing them to continue this application?
If we were to vote it down tonight, does that mean they could not come back to us with a redesign?
Exactly.
That's right.
And there's no way of taking a straw poll to see how we feel
Well,
tonight.
we don't have a motion to take a straw poll against. I mean, there are a lot of things up in the air.
Well, the other thing we could do, quite frankly, is we could withdraw the application. I don't have to. The downside to that is it's no longer on the agenda. We start over again, new fees, and all the like. An adjournment is a more efficient means of doing things.
Yes, Michael.
I probably lean towards hoping it gets voted on tonight, but if they want to withdraw it, I would feel better that way because they would then have to notice the neighbors. And they were noticed a whole long time ago and has never had to be noticed again. And I recognize the point, how few neighbors are here. But that could be a function of the fact they were noticed, what, September?
Yes.
And I see it as being a strain on them. So
a strain on whom?
On neighbors to keep up with it. So if you want to withdraw it, then
the only two neighbors that have ever shown up were the two neighbors that testified tonight.
That is not true. In the
That
first
is
case,
not
the
true.
neighbor behind showed up.
Yeah.
All right, let's
And
no,
this was early September.
wait.
No, he
Wait.
wasn't around. I took notes on that. There was more than two neighbors that spoke. So that is not correct.
Look,
Karen,
in order to move this application along, the applicant is asking you for an adjournment because they want to consider a redesign. So is the consensus of the board that that's acceptable to you?
can we ask that this be renoticed?
Well, you can't make it a condition because, I mean, the MLUL, once it's been noticed, once we have announced, we're carrying it to, that's why we always announce a certain date.
Sure.
I don't think you can make the applicant do that.
Okay.
You want to ask them to do it, well, you can, but they can't be required to do that.
Okay. Would you renotice?
I'd have to talk to my client. I mean, my client has talked to other neighbors. It's not as if they've been in a vacuum. My inclination is we would not renotice. I knew that being done ever. Can you hear me, by the way? My iPad's
Yeah,
died.
we can hear you. We can hear you.
That seems extraordinary to me. We can.
You don't have to do it.
No. Well, no, he wants to make it a condition of.
No. I'm not. I'm asking you voluntarily.
No.
Would you do it? I'm not requiring it to be done. I'm just asking if we suggested that you do it, would you be willing to do it?
I would advise my client against it. The law does not provide for it.
Okay. That's fine.
Can I ask something?
No, this is not, I'm sorry. That's not the forum for this right now.
Well, listen, if you're so concerned about the neighbors, why don't you let her ask her question?
Okay.
Well, Mr. Piepzak has apparently talked to many neighbors except to us who are his closest neighbors. I appreciate he wants to redesign, but before they start redesigning, it might be a good idea to talk to us and see what we could live with. Say thank you.
It's an excellent suggestion.
I would be very happy to do that. Person, yes.
Is the consensus of the board that you're willing to carry this to date certain, another agenda, to allow the applicant to review a redesign with their next door neighbors and to come back to you with a revised plan?
Do any board members have an objection to allowing them to continue the application, to carry it?
We can take a roll call vote. I thought it'd be easier just to do this by consensus, but if you want, we can do.
No,
roll
it's
call
fine.
vote.
I just want to know if
Yeah.
anybody objected. That's all. I thought that would be the same thing. Yes, Donna.
I don't have an objection. I just want to understand that this is still an FAR case, whether there's a redesign or not. This is still an FAR.
Right. Right.
Okay. I just want to make that clear to the applicant.
We understand that.
Okay, great.
All right, Karen, do you want us to verbally vote on this?
why don't we say, do all in favor to carrying the application? I don't know what the next date will be. Derek, do we know?
It's gonna have to be in June. I mean, April is booked. May is gonna have to be rescheduled. I believe Claudia is gonna be out of the office. So it would have to be June or July. And we have a lot of other cases that have just continued to get backed up because we have cases that the board has to, that keep getting kicked down the road. So
From the for the applicant, is there an issue whether it's June or July?
No.
All right.
I
So,
mean, I'll be away a portion of June, so I prefer.
all right. So if it were carried to July, that would be, is that July 22nd?
That is July 22nd.
Yes.
Now, I will make one comment. I don't know, the applicant is not required to renotice. In past situations, some applicants have indicated they would be willing to send out notice by first-class mail, not certified mail, which adds another level of requirement. So I don't know if the applicant wants to consider doing that, but as we've discussed, they're not obligated to do that. So, so do
Karen?
you? Yeah.
I need an extension.
Okay. So if this is carried to July 22nd, Mr. Yoskin, and do we have your consent to an extension of time?
Yes.
That would have to go through July 22nd.
Yes.
Okay. So now, board members, why don't we just say all in favor of carrying this application to July 22nd, 2026 to allow the applicant the opportunity to confer with their neighbors regarding a redesign of this project. Do we have? We can do this by voice. Okay, we got 1, 2, 3, 4, 5, 6. We have 6 in favor. Any opposed? All right. Well then, I'll take that then that we've got the consensus to carry it. So for those who were watching tonight, it will be carried to July 22nd, 2026 at 7:30 p.m. It will be on the board's agenda with the information for logging in to the meeting so that you can participate remotely.
Okay.
Mr. Chair,
Yes.
just one comment, and it's more to any neighbors that are still online. You can advise your neighbors and let them know.
That's true.
Since they're not going to get even a uncertified notice. So pass the word and people can speak their mind.
Thank you.
Okay. Thank you. Good comment.
Yeah, well.
Okay.
All right.
Ready
All
to
right.
move on to?
5-minute break,
so-
Steve.
I'm sorry, Steve?
5-minute break.
5-minute break. All right, this application is come to a close. We'll take it is 9:44. We'll say 9:50 we will come back in session. Thank you.
Hi, Ryan. Do you want me to move anybody over?
Yeah, indeed. If we could do, I don't know if actually she needs to, but Carmen Wolf is with us. Lee, who's raised his hand, is our traffic. Ruchi, our architect, and Steve is our planner.
Got that board reporter in?
Yes.
Oh, thanks.
Okay, it's 9:50. Are we all back? Okay. Okay, we'll go on now to our second application, 10 Humbert Place, case number Z25-667, block 25.02, lot 77 in the R4B zone. Mr. Bridger, Ms. Gribben, does someone want to say something about this application before we start?
Yeah, no new information's been submitted except the presentation that the applicant is going to put on tonight. So I haven't seen any
Okay.
new plans other than that. So I would let him.
Okay, and again, Karen, this didn't require renoticing.
That's correct. It was carried and we announced this date at whenever it was carried, we announced it publicly, so.
Okay, so who's going from the applicant standpoint? I see a hand go up. Mr. Kennedy. Okay, please
Good evening,
begin.
Mr. Chairman. Good evening, Mr. Chairman. Claudia, with apologies, I left off one person, the applicant, you see Tanu at the end, the bottom of the list. You can bring her or actually both of the applicants over under that one name. They may have a thing or two to say as well. Good evening, members of the board, Mr. Chairman. My name is Ryan Kennedy from Stevens and Lee here for the applicants. If you recall, we did get through our presentation in, gosh, it seems so long ago, but at the January meeting, there were two core things that the board was interested in seeing more from. One, there were some excellent suggestions about the layout of the parking area. There were some thoughts that there was more room. Maybe a K-turn area could be put together to better allow a car to turn around before getting onto Humbert Place, which is a private road. And we brought on a traffic engineer. Our architect redesigned that area. And as often happens when things are discussed before this board, it was an excellent idea, and we were able to redesign it, and we'll show you with our traffic expert how a car could turn around with the modifications that we've made. We also went through, and there was some thought about, well, redesign the whole thing, frankly. What would it look like to build a similar house elsewhere? And there's no compliant place on this lot. It is an undersized lot, essentially landlocked, but for the private road. But there are places where it could be technically more compliant, and we looked at that, and we think you'll agree, but we'll talk through that. It's just not a better design. It results in no usable open space, results in a parking arrangement that probably really won't work, or certainly won't be the upgrade access-wise from the current situation. But we looked at it, and ultimately want to talk you through that, why we think that the original design, which uses the foundation of the existing home, clustering it on one side where it is now, filling in where there is a current covered porch with an addition that, again, does not add any units, does not add any bedrooms, but does modestly increase the home to make it more usable, keeping parking generally in the same area where it is today and has worked for some time with the current home, but actually reconfiguring it based on the board's suggestion, so it should be more maneuverable. Ms. Casey, I'll apologize. Certainly one of our witnesses was not sworn in, our architect, and I believe while we didn't actually get to our planner, they probably were sworn in last time. Our traffic expert, Mr. Klein, certainly was not. He was not part of the project at that point. But if it would make sense before we start the presentation to swear them in, or we could interrupt when it's Lee's turn for traffic. And
No, that's fine. But so we have Mr. Lydon, Mr. Klein, and your client, Tanu Bhatti. Is that right? All right. So if you'd all unmute yourselves, and do you swear or affirm that your testimony this evening will be truthful?
I do.
Thank you.
Okay. We also, as Mr. Bridger noted, and I guess I'll say collaboration. But again, the more time people look at things that are on a challenging, interesting, quirky lot, this is a site where there are numerous existing, pre-existing non-conforming situations. There is technically no front yard for this lot because it doesn't front on an actual street. It fronts on a private lane. But our architect and Mr. Bridger and Taylor, they looked at it, and there is, and we'll make sure we note this, their updated memo resulted in, I think, one fewer variance, even though the project didn't change particularly much, but some reworking of some of those variances. We'll just make sure that we're clear on what they are, and much appreciated. Again, the more eyes on this, the better accurate, I suppose, mostly the current situation is able to be described, that we are changing as we expand the property. So we did. So we had one exhibit last time. We have a totally new exhibit. So perhaps if it's all right, we can mark this, what we submitted for this hearing, as our second 882 perhaps, and we'll keep both. They're not. They don't run consecutively. And I'll start with.
Do you know how many slides it will be, Mr. Kennedy?
There are 19, but looking at the hour, I know I'll show you that many of them are quick ones. Okay. I'll say that. I'm looking, apologies, we have our Hollywood Square situation, and I'm looking for our architect who was in the room when we moved over, but I do
don't
not see Rishi at the
see
moment.
her on the
I don't know
screen.
if she dropped off. She's back on the attendee list. The last one, Claudia, on the bottom. If we could try to move her over again. Many thanks. So while she comes back online with her camera, if it's all right, I'll share what we will talk about as being our second exhibit. Rishi, we have you.
Yes, I'm here.
Ms. Dar,
Now,
I know you
you
were
were-
sworn in previously, so you remain under oath.
Okay, thank you.
Thank you so much, and apologies to you for my delay in getting you asked to be moved over, but I'm glad we have you here now. So we've got a couple of slides here. We'll talk through, and we'll interrupt the initial presentation just for so you understand where we're going with this. We'll have our architect take us through some of the changes that the board suggested that we've implemented. We'll then kind of pause with our traffic expert to kind of prove out and go through the testimony to show why we think that works and how it works better from an access perspective. Go back to our architect and talk about the kind of alternative design that we explored that, again, we don't think is better, but we wanted to make sure we explored it and we talk through it. And then we'll close with our planning testimony this evening. Hopefully I'll be able to actually scroll through the exhibits. Oops. So Rishi, if you could, on this second slide, just remind the board where this property is. I believe we have it highlighted in yellow on the left and the zoning map there on the right.
Right, that's correct. It just shows where the location of the site is. It's marked as R4-B zone. So this is just to give a brief idea about where the location is. If you can go to the next slide. Yeah.
Well, I was going to say this essentially we believe has been superseded by Mr. Bridger's memo from Friday. We did our exhibits just before that. Rishi, though, if you want to just briefly go through, some of the changes here. I know we have like variant C was initially listed as been eliminated, so our list goes A through L, whereas the new zoning memo goes A through K. But if you want to just briefly walk the board through the changes.
Yeah, so mainly the variances that we are asking are the side setback, which is basically on the north and the south side and the west side, because the east side faces the driveway and the parking spot. The second main variance is the height to the setback ratio, because this is a pre-existing condition where the lot itself is it's an odd-shaped lot. So we have the height to setback ratio variance that gets kicked in for the north-south and the west side elevation. The last item on the list is the distance between the neighbor and this building, which is the 10 feet requirement, and we have 9.4 feet. So again, goes back to the condition that we are keeping the basement of the house, and this is a pre-existing condition. And what we are doing here is basically doing an addition towards the east side of the house and rebuilding the first and the second floor.
Moving on to the next slide, I think you've highlighted in the bulk
Yes.
chart, again, those basic categories of variances that we talked about last time, but again, as modified by the updated zoning memo, removing one of the variances that just ultimately wasn't necessary.
Correct. This just shows the diagram about the height and the setback ratio. We just wanted to have a slide in there just in case we need to go back and see.
Yeah, and just to remind the board, looking at box A, the south elevation, really the left or western wall there essentially is the current condition. However, if the board remembers, you can take them through the updated roof design and why we pursued that and perhaps why that makes the numbers change slightly from the existing condition. Those are just what maybe you could explain why we updated the roof design from the existing condition from that.
So we had the regular gable roof, and this type of design is the shed roof design, where basically why we did it is two reasons. One was the stormwater management. This is a better way of addressing all the rain that falls on the roof. It just stays away from the neighbor, which is on the west side of the property. So this roof condition, the roof design, and the way the architecture of the building came up with was a better approach in addressing the height to the setback ratio, and also answering the stormwater management.
So no changes there, but that's just a refresher from from last time.
Yeah, no particular change in that.
Now, there are a small amount of changes, but ultimately still a compliant application as far as coverage goes. We'll talk about on the next slide the changes that we made based on the board's comments about maneuverability, in the parking area, but ultimately still remain compliant from a coverage perspective.
Yes, and one thing which I want to point out is I did do a chart specifically for the existing impervious coverage. And what we have as the proposed is under the allowable. So we are not exceeding that number. And I wanted to see the difference between the existing and the proposed, which is basically just a 14% ratio increase in terms of the extra impervious area that is happening with the proposed design.
And that number, that actual from a square footage perspective is 384 square feet. So less than the 400 in Princeton that would trigger stormwater mitigation. Is that right?
Right, that's correct.
So moving to slide 7, this is an updated, I hesitate to call it site plan, but sketch of the property. You want to talk about, one of the core comments we got in January was, look, there's some room in the back of we'll call it the backyard, although of course, unfortunately, this lot is unique and does not have a rear or front or side yards, but what we'll call the back, the place, the green area, I suppose, open space to the east of the property on the right side of the screen. But there's some comments where if we maybe reconfigured the porch, perhaps made a little bit more room for maneuverability, it might be a lot easier to get in and out of the site. So maybe just talk the board through a little bit about the changes, and I might be able to zoom in a little bit on that.
Sure.
Those are famous last words of.
So I'll have Lee go over the circulation diagram, but very briefly, I'll talk about the relocation of the steps, basically the new steps on the east side. We moved them, we kind of reduced them in width, and we now have a shorter footprint for the deck or the steps leading to the backyard. And that gives us more space for the car to turn around. We do have the metal bollards just as an extra safety measure for the car that is backing and coming out of the site. So yeah, those were the two main things. We don't have a shed at the back, so we have more space for the client to enjoy the side yard or the east facing part of the site. And we try to stay within, give more area for the grass and more green space, and still give more justice to how a car is going to come in and come out of the site.
And just as a reminder, this hatched area is the new addition, but this area in front represents the existing porch. So ultimately, the parking area is more or less unchanged. The entrance is similar to the existing condition. And again, based on the board's comments, where the steps had been, which was close to the entrance, had been moved. And Rishi, you kind of found some extra area for, we'll see in a minute, a K-turn area, I suppose, so that a car can back in and out. And then instead of possibly having to back all the way out to Humbert Street, down Humbert Place, which might be what happens now, that someone would be able to turn around on the property and then actually drive forward all the way back to Humbert Street.
One thing I would like to just add and correct, the front porch, we did add slightly to it. It's about a 2 feet 9 inches addition to the existing front porch in order for the house to basically, the entrance door is what made the addition to that slight addition to that porch in the front. So that was the only thing I want to add, but yeah. Other than that, I think I explained we are adding 377 square feet on the first floor, then doing a second floor addition on top.
Now, if it's all right, Mr. Chairman, we will come back to the architect, but if it's okay, I'd like to introduce our traffic expert at this moment. I know there may be questions for the architect. Happy to answer them, but she will be back momentarily, and perhaps some of the things that board members might be thinking could be answered then as well. But I'll leave it to your discretion.
No, that's fine.
All right, perhaps in the interest of time then, and I will, Lee, I'm going to pull my screen down a little bit so that the board can see you more fully. And if you could just introduce yourself and go through and again, looking at the time quickly, I know you've testified in many places before, go through your credentials.
Yes, hi, my name is Lee, middle initial D as in Daniel, Klein, K-L-E-I-N. I'm the principal of Klein Traffic Consulting in West Orange, New Jersey. I'm a licensed professional engineer in the state of New Jersey. My license is current and in good standing. I'm also a nationally certified professional operations engineer, and that national certification is also in good standing. I've been accepted as an expert in traffic engineering at well over 150 planning and zoning boards throughout New Jersey.
Mr. Klein, we will accept you as an expert in your field.
Thank you very much, Mr. Chairman.
Many thank you, Mr. Chairman. I'm going to put the screen back on, and we're going to be on slide 8, which, just so Lee is not surprised, is going to be a traffic diagram that he put together. So give me 1 second to do that. Here we go. And just if you want to take the board through what you did here, what's represented here, and let me know. I can zoom in a little bit if it would be helpful, or leave it as is.
Zoom in a tiny bit, but what I did was I took the site plan that shows Humbert Place, the private drive, the easement area, and then I developed a turning template where the vehicle would come in head first from Humbert Street, head towards the property, make a left turn into the site, pull to the right, and basically parallel to Humbert Place, park their vehicle. We had a couple of iterations of this, but this is the way we ended up. So if you want to go to the next slide. So now for that vehicle to come out head first, as Ryan had said earlier, that vehicle has to make a couple of little K-turns here, and then they're able to face, face south to make the right turn to go out to Humbert Street. So we did that using the turning templates of Auto Turn that comes from AutoCAD. It was done under my supervision. Again, we were provided with a PDF of the site plan, the way you see it, without the parking area. I did these maneuvers, and then Ruchi designed the parking area around my maneuvers.
So maybe just as a follow-up then, so based on the improvements that were in design to the site and your analysis, I don't know if you want to speak to whether this is an improvement over the prior design we showed the board, but will this allow a vehicle to, I'll say, head first in and head first out to the parking area?
That's correct. The first exhibit shows the vehicle coming in head first, basically parallel parking or facing east. And then in this slide, when that vehicle is ready to leave, they do a little series of K-turns, and they're able to face head first south, make the right turn out of the driveway, head down to Humbert Street head first.
And I imagine some of the team has shared with you how things work now, but perhaps that's an improvement from the current condition that exists on the site that may not allow that.
Yeah, correct. To come in head first and to come out head first is obviously the best way to go, and that's what we're providing here.
Many thanks. Mr. Chairman, I don't want to oversimplify, but I'm happy to have our traffic expert available for any questions before we go back to the architectural and other site testimony. But we wanted to be extra sure that, one, we listened to the board's comments about changing the site back there, and two, really showing that it actually would work, frankly.
Board members, while we have this while we have this diagram on the screen, do you have any questions about the maneuverability of a car to pull in, turn around, and pull out the front?
Just one quick question. When you said a series of K-turn, is it like maybe 2 back and forths or many back and forths?
No, it looks, if you can see the outline of the vehicle, it
Yeah,
starts
looks
off
like 2.
facing east, it pulls back, forward one more time, and then back. Yeah, so
Okay.
it's however you want to talk. So it goes backwards once, forward once, backwards again, and then it comes out.
Okay.
Okay.
With apologies, I just got the Austin.
Go ahead, I'm sorry.
What was that, Brian?
Well, apologies, it's too late. I was going to make a terrible joke, and I'm regretting it already. So apologies for interrupting.
As you should. Okay. Okay, board members, any other questions of the traffic engineer?
One other question, just
Sure.
quick question. Is there any traffic on Humbert Place?
Is there any traffic on Humbert Place? I believe the neighbor to the west parks their vehicle on Humbert Place, but as far as through traffic, no, there's no through traffic.
There's
It's a
no
dead
through
end.
traffic, so,
Correct.
okay.
Okay.
Yeah, I'll perhaps just highlight, this is going back a couple of slides. Directly to the west is a duplex who would use it, but would not be traveling necessarily east of our site. And then to the south, the property that it's actually on would in the future be used. There's currently not structures built on that yet, but there would be in the future.
Okay, thank you.
How many cars do you anticipate residing here?
Steve, I believe that not Steve, that's our planner. That's next. Lee, the requirement is 1, and we've shown and have 1 spot on the site. I don't want to get too much into it. There are some potential, there is room on the easement area for parking, and we prefer not to rely on it necessarily but ultimately we show the 1 on the site, and that's what's required under the ordinance. There's a few properties that including ours that under the access easement have a right to park kind of a spot on the parallel, but we wanted to be absolutely clear that we could comply without using that.
And am I right, this is to be a 3-bedroom, 3-bath house? Are my notes correct?
I'll let the architect confirm when she comes back on. Certainly 3 bedrooms before and after. We are adding bathrooms. I believe it is 3. I think you are correct.
Yes.
Lee, thank you so much. Richie, I'll bring you back. We'll kind of summarize again, remind the board a little bit about the design here, but ultimately the kind of buckets of variances. But if you go a little bit into the reasoning and some of the positives that our planner will touch on later about the using the current location and expanding into the porch area rather than, as we'll show a little bit later, an alternate design, more in the center of the lot.
Sure. I just want to address, yes, that's 3 bedroom, 3 bathrooms. That was asked earlier. And going back to this slide, this is just to give an idea of what variances are requested. So we have side setback variance, the height, the building height to setback ratio, and the distance between the building and the adjoining building. One of the reasons why we did it is the sustainability aspect of it, where we are keeping the existing foundation of the existing house. So that itself would reduce the carbon footprint, that would reduce the construction waste in case there was a scenario where we completely demolish the building. And even the excavation that happens due to the new construction also causes a lot of site disturbance and excavation cost for the client also. So those were the main reasons. One of the important reason is the sustainability part of it and also the economic aspect of it. The other positive part is that the client gets to enjoy the side yard. We're providing 1 car space in the site for the car to enter and exit out. but it still gives them adequate side yard space in case they want to do a barbecue at the back or sit and relax and enjoy the side yard. One of the other conditions is the design of the building, which we are making it better. The elevation itself is improving the look and feel of the house. It is more light. It gives more light to the people living inside the house. It gives more space to them. The ceiling heights have improved from what was existing. We're now giving 9 feet ceiling heights to them. And on top of it, it's better stormwater management in terms of addressing the rainwater for the house. So yeah, those were the couple of important things I wanted to highlight.
And I guess to the bottom right corner on the positives, even if we were not having the benefit of reusing the current location or the some of the benefits from not reconstructing a foundation or a basement, but ultimately, as we'll show later, this is the layout that we'll see is the most accessible for cars. The other ones are something else would be quite challenging, just the way the easement is set up. And further, piggybacking off of or expanding from the existing home location does allow for, we'll call it a backyard, and some usable open space rather than the open space being kind of surrounded, like the egg white of a yolk where there's just a sliver kind of around or covered with parking.
Yep.
So again, those 3 buckets, Rishi, I guess the economics, sure, but the sustainability and more importantly, the access and creating an usable outdoor space.
Yep. Yeah, these are just few slides showing the existing footprint, the proposed, which is highlighted in yellow. And that's if you can go further, Ryan, that's the first floor where the highlighted is the proposed area. Again, 3 bedroom, 3 bathrooms. Upstairs, we have good sized bedrooms and a staircase, 9 feet ceiling height on both the levels. And then we have the roof, the before and the after. This is how it is existing on the left, and then the right shows the proposed elevation of the house. The side steps that we added towards the east side have a roof canopy, just so that somebody who's coming out of the house has some kind of a roof while they're coming out. If you want to go to the next
This shows
slide.
This shows again, instead of the front gable, the pitched roof to bring water away from the alley in the neighborhood.
That's right. That's from the east side of the elevation, the before and the after. And then this is the side facing the neighbor. One thing I want to point out is that we have minimum openings, or if you can call it fenestrations, facing towards the neighbor. So it's only 5% of the facade. That way there's a level of privacy maintained between the neighboring building and this building.
And that's actually a reduction from the current windows, which are a little challenging neighbor-wise.
Yes, and the walls would be fire rated. It's basically the vinyl siding, but the exterior walls are going to be 1 hour fire rated.
And that's another improvement from the current condition.
That's right. This is basically making it more better in terms of the code and in terms of the fire safety regulations. This is
on this next.
Go ahead, Ryan. Sorry.
Okay. All right. So one of the other things the board asked us to look at is like, well, there was some skepticism. Obviously the whole reason for using the existing structure isn't just the saving the cost of a basement. While that's part of it, sure. And there's the environmental aspect of not rebuilding something that's good, but that's already there. And usable, but ultimately, well, is there a more compliant location? And we looked at, well, what would happen if we tried to build a similar modest-sized house in the building footprint? And we tried, and you can come close, It still needs quite a few variances, but Rishi, you could talk us through it. But the thing that, because of the other constraints on the site, namely the easement locations and the need for parking, we end up with a layout that unfortunately is quite a lot of pavement, not a lot of usable access for a car to get in and out, and unfortunately no usable open space. We're kind of left with these slivers of side yards rather than kind of clustering a usable open space in the back with the home clustered kind of where its current location. So you want to just kind of take us through what we explored here. And obviously this is not a full design. This is just the idea of where a home is. There's other challenges, I'm sure, in you actually designing a trapezoidal home. But assuming you could, maybe talk the board through it.
Yeah, so we last time we listened to all the concerns the board had, and we tried to see what this approach would lead us to. So the red box that you see is basically the minimum setbacks, and we tried to stay within that, but we also had to meet the square footage. So within that number, we still trigger variances. We have the height to setback ratio variance, which is still the same what we had at the first place. The second is the distance between the two buildings. That's also the scenario. The third one was the parking. The parking, we showed it on the side, which is towards the east side, right? And as you can see, it's too close to the lot line. Typically, it should be 4 feet off the property line. And this one, with this approach, we are getting about around 2 feet distance from the asphalt paving to the lot line. So this approach did not reduce too many variances. We still have many of them with this approach. And as you can see at the corner of the property line, there is a utility pole. So we also have to consider that in terms of the location of the parking and everything else. And on top of it, I mean, it's basically parking in the front is not the driveway completely in front of the house, and parking very close to the house and to the neighbor is not a very pleasing approach, I would say.
And just to note for the board, I'll try to zoom in a little bit here, but this essentially to make this even attempt to work, we're really kind of paving this whole front area. Now, admittedly, it's not a front yard because this unique lot does not have a front yard, but it's what you'd kind of expect the front yard to be. And here, unfortunately, whether instead of having kind of a more of a neighborhood friendly approach to it, you've got a lot of pavement that kind of creates an entire paved area between Humbert Place and the parking area. And Rishi, do I have it right that this existing area, which is a feature of the access area and the easement and not our property, is a sidewalk? So actually you'd have to kind of hop over this sidewalk sort of to get to the parking area and then try to maneuver this kind of S maneuver around to avoid some of it through the front yard. Is that more or less what someone would have to do?
Yeah, that's the existing concrete walkway, which is there, and we're not touching it. So obviously they'll have to, it would be hard in terms of maneuvering the car, and the location itself is not a good location for overall the design, the look and feel of the house, and even for the neighbor.
Time to kind of zoom back out here. And we call this design option, but it's our attempt to kind of show where else a home could be. But you want to just take us through what we still need quite a few variances, but what the I guess maybe summarize again what the issues with trying to be not compliant, but a more compliant location.
Yeah, so variances are still there. I listed them, and the parking and the asphalt paving, it dominates the front and the west side of the lot, creating a very undesirable location condition. And moreover, the side yard that we are left with, it does not give any space for the homeowner to enjoy that yard space, because as you can see, that layout kind of the paving and the asphalt driveway dominates the site, which should not be the case in in a single family home, the home should look like a home, and driveway should not be dominating the property.
Thank you. With that, before we get to our planning testimony, certainly
Can I
welcome
just,
any questions that we have for
Mr.
our architect.
Kennedy, can I just interrupt you for a second? I'm very sorry.
Yes.
Karen, Derek, it is 10:26. We have one other application this evening, 105 Mountain Avenue. We're obviously not going to start it before 10:30 at this point. And unfortunately, I have to, because of a personal reason, I can't go beyond 11 this evening. So do we want to instruct anyone in the audience or the applicant that maybe we'll have to carry the Mountain Avenue project to the next hearing?
Yes, sir. April 22nd.
I mean, Claudia, can you bring over the applicant for the Mountain Avenue application so we can just explain this and we can get her, make sure she's aware? There she is.
Okay. Karen, do you want me to explain it or do you want to explain it?
Sure. Ms. Goot, because the board isn't going to be able to go past 11 o'clock tonight, we're not going to reach your application. We'd like to carry it to April 22nd. You would not have to renotice. And that's pretty much the option we have for tonight. So we just want to make sure we have your consent to do
Yes,
that.
I totally understand. But April 22nd would not work for me. I'll be travel internationally. Would that be another date available for us?
Yes, there's the May meeting.
The May meeting is problematic.
I don't
have
know
a
if we
date.
want to go late, but we do have a vice chair.
That's,
We can't go, I mean, you're talking.
This is a variance.
It's a lot of variances. I mean, it would be the June meeting,
Okay.
which would be the 20,
June 24th.
yeah.
Okay.
Is that acceptable?
Can you give me a second? I just need to check my calendar.
Sure.
June 20. June 24th, that's a Wednesday.
Yep.
Okay.
Karen, and we need an extension too.
Right.
Thanks, Claudia.
Yes, I think that will work. But I will have to double check with my engineer and architect to confirm with their availability to be able to be present at the meeting as well.
All right, let's do this then, Ms. Goot. So
I think they're actually both maybe waiting, and Kathy
okay, to be
Miller
brought, yes, let's see.
and
if we-
Steve DeRocci.
Okay, hold on. So let's see, that's, yes, I see. And is that Kathy Mueller or is that yours? Is she your engineer?
Yes.
All right, Claudia, can you bring them over just so they can confirm their availability?
And Steve DeRocci, our architect, it should be on the call as well.
There's a John DeRocci.
That,
Well, the
Oh, here, he's here. He's here.
Yeah, I'm here.
Okay, so Ms. Mueller, Mr. DeRocci, are you also available on June? Let's make sure we've got the right date. June 24th.
June 24th, I'm good.
You're muted, Ms. Mueller.
I'm sorry?
No, you're good. Ms. Mueller, you're muted. Are you saying you're available or we can't hear you?
Kathy, are you on mute? We cannot hear you. Maybe you can text.
Nodding, okay. Okay, we've got
Okay,
it.
good, good.
All right.
Okay, thank
And
you
then,
very
and
much.
then Ms. Gu, we're gonna need an extension of time because the board has only so many days within which to consider an application. So we need you to give us more time. And we would need you to give us an extension of time to hear your application. I'm gonna say through June 30th, just to be on the safe side. So do we have your consent to that?
Yes.
Okay,
Hmm.
great. Okay. Then I think we can return to 10 Humbert.
Do you want to make the announcement about the members of the public?
Yeah, I thought I had, but I'll say it again. For anybody in the public, the application is being carried to June 24, 2026, 7:30 p.m. Will also be on the board's agenda for that meeting with information about how you can log in if you want to participate remotely, and the applicant will not be obligated to provide any additional noticing for that meeting.
Thank you, board. Thank you, Kathy and Steve, for being here tonight.
We're good.
Okay,
Okay.
thank you for your help. Okay,
Bye.
let's
Thank
go
you.
back to
Good night.
10 Humbert.
Thank you, Mr. Chairman. So at this point, that's our architectural testimony. So happy to have, if there are any questions about the property, about the design, about the changed parking area, or what we explored with the alternative design, happy to answer them now.
Well,
Yeah, I have.
yes, Michael.
I'll try to make it quick. On the alternative drawing you had, could you quickly explain to me again the easement that would require all that concrete in front?
Absolutely. Let me see if I can bring it back up. It should be easier than I'm finding it. Hold on. I will. Oops. Zoom in a bit. So, and Rishi, stop me if I get any of this wrong, but I'll just, in the interest of time, I'll just kind of describe it for you. This dark dotted line represents the property that we're talking about.
Right.
The in front of that is Humbert Place, which is a private road and an access easement that goes east to west, to the left, east to Humbert Street, and then kind of stops here at the end of our driveway. That is a legal easement that's been recorded with the deeds. That is for our access and the neighbor's access. But we don't have the ability to make physical changes to it. So there actually already is this, and I'll see if I can zoom in more. There's a sidewalk here, existing concrete walkway. That is a feature of the easement already. We don't have the ability to change that, and it is kind of between us and the the proposed, this possible parking arrangement and the access area.
Okay. And I expected to see not a fully compliant alternative. So I was surprised to see the alternative setback so far. I actually expected to see it like 3.8 sort of up, sort of naturally, and not having it set back so far and probably being not as wide. I was surprised to see you have it set back. What's that?
Maybe just to understand, maybe like a something kind of in between, something a little closer to the original design, but just slightly further away.
Yes. So, close to Humbert Place. Only like a 3.8 setback from Humbert Place.
Consistent with the duplex next door or the next door.
And then you could have had a...
Richard, so we looked at that. Richard, maybe you can take us through. The problem is that to get onto the site, the easement access I think what you might be thinking is, well, you would, I don't know if you can see the little hand cursor here, but a car would like sweep around here and be able to park here, perhaps if we moved the house further back, for example. Our ability to enter the site ends kind of where the current driveway is. The easement ends and doesn't go all the way to the back of the property. So we explored a couple different ways, but the magic of the current location is that it's clustered enough to the front that we can still get to the back and park. If even moving it back a couple of feet cuts off that driveway area, frankly.
Well, let me ask you,
the
Mr.
options really
Kennedy, are you saying that in order to get with this scheme, and I understand what Michael's saying, and I think he's right, with this scheme, you've got to go past, you come into the property, go in, you make a left into the property and a left again, and then a right?
Yes, or you hop this curb, essentially hop the sidewalk.
Can you just come down Humbert and turn left into the property?
Yeah.
And then you don't have any paving in the front. And then Michael's exactly right. Move the house forward. It would be a far better scheme than forcing the, again, I think it's, in my opinion, it's a far better scheme than trying to modify that existing house. I think when I look at it, the cost of doing all those changes to that existing structure and adding on to it is going to far exceed what's going to cost to build a new house, which could be, based on Michael's description, far nicer.
So, Rich, you want to comment on that? Again, I think what you're describing would be coming down Humbert Place, making avoiding the utility pole here, and there would be a parked car as well behind it to
And
make
turning,
a left across the sidewalk, though, essentially.
well, why can't you do that? That's typically
Everybody crosses the sidewalk if you got one.
Why are we redesigning it for them?
Well, we're just trying to.
Are there fewer? I thought it was essentially the same number of variances needed. I thought that's what I heard. Am I wrong?
Well, I would.
There are fewer.
I would love to see more distance between what are now the two existing, because it doesn't quite meet code now if it's done in the same place. And also I thought of more logical parking.
But they like it the way it is. That's what they brought to us. That's how they want to do it.
Well, they
Okay, thank you. I understand your point.
But
my question still stands.
Yeah, but Eve, they came to us with this alternative.
Well, that's because we asked for it, I believe.
Okay. I
Okay.
mean,
Can I make a comment?
Okay.
Steve?
Yes.
Two things. When I redid the bulk chart, I left out the variance for the expanded porch that runs along Humbert. That's 1.5 feet, it appears to be, so that's a variance. And then looking at the survey, which appears to have been done for the previous owner, as we note, the setbacks at the northwest corner of the property, one is 0.1 feet. That's 1 1/4 inches.
Right.
The survey has no boundaries, pin set. So how do you build a building 1 1/4 inches back from a setback without a survey that doesn't have any? I mean, that was the point about looking at a redesign, was you're 0.9 feet away from a property line and you're 0.1 foot away. And that's not, I mean, if you have the opportunity to address that, I think you should, what you're trying to do. But I mean, that's.
So you're
how
saying
do you do that? How do you do that with this survey? The pins.
You really need an accurate survey then. You need a new survey. Is that right?
If I can add, that's the existing, we're keeping it the way it is. We are not removing or redoing the foundation for that existing part. So what stays because that's an existing outline of the structure.
But you're rebuilding on top of it.
Yes, so the
I mean,
foundation
we don't know
stays.
if that existing is there or not, because no pins are set.
I'm not sure I followed. So the question that
There's no boundary
quality of the
set on the survey. They signed a waiver, or they say they purported to sign a waiver. A written waiver and direction not to set corner markers has been obtained from the ultimate user pursuant to PL 203. That was a whole discussion about moving the building back a few feet from the property line.
I don't remember us talking about this survey not being.
But it's still the same.
It's the same issue. You're building an inch from the property line without a survey with pins.
You'd have pins at the corners so you could actually physically see the corners of the property. And then you can accurately determine where the distance of the home is from that property line. But without pins, you can't see anything.
Well, I'm just surprised that we're just now discussing this. I don't remember that coming up or even being the reason for them to consider repositioning it when we talked about this last time. So I'm just surprised that we're now doing that.
They can choose to keep this the way it is, but I think Derek's point is good. You know, how do you know how accurate this thing is without having any markers to identify the property corners?
They're done either with corners or from other references. I mean, I don't know what to say other than that. The location of that corner is fixed now, and the proposal is to keep it as in its current location. I understand better now, I think, what some of the board members were looking for, which I think is to take this project and we would say kind of unnecessarily shift it, rebuild it several feet over. To that point, though, the part that we can address, though, is that because of if that was the desire, maybe we would have cut this off then. There is, even without moving it over at all, not 3 feet, not a foot, not an inch, we had to revise the step location to make it even work from an access perspective. So if we were to move it several feet over to create a little bit more of a buffer, I suppose, from the existing condition and rebuild the house several feet that way to the west, we would run into that choke point and have difficulty getting a car into the back of the site. And that would be a negative change from the current situation.
I think we're talking about two different things. But if this is the scheme you want to go with, leaving the left section of the existing building in place and adding on to the right, then, you know, we still need to make sure that back wall is actually accurate. Then you have the issues you're building on the property line. How do you physically do that?
No, understood, and we would certainly make sure that we are not encroaching onto the neighboring property.
How do you physically finish the neighbor's side of that wall without going onto his property or working on his property?
Well, if we needed that, we would have to obtain access. It's a fairly common thing for tight sites in Princeton.
Okay, it's fine.
We've addressed that, and we understood that if the board's approval of the design or these variances is not your invitation for us to trespass onto another property. We understand. If we couldn't, if a neighbor denied us access, we would not be building potentially. You know, if there's no way to get on and finish the section from our side of the lot line, we didn't have permission, we would.
It's fine.
That would be a challenge.
Let's just move on from there. So we're not going to consider the alternate location. We'll just work with this. Fine.
So we do have our planner here. He was sworn in last time, but Steve, I don't believe we got your credentials out of the way. If we could very briefly, considering the hour, I know you represent many boards that have testified all over the state, but briefly introduce yourself and your credentials as a professional planner this evening.
Sure. Steve Lyden here. I'm a professional planner, as Mr. Kennedy just said. Rutgers graduate many years ago. I've been a licensed planner since the mid to late 80s. I used to work for a couple of municipalities. I was also a planning director for Morris County Community. I've been with Burgess now for 25 years.
We'll accept you. We'll accept you as an expert.
Thank you, Mr.
Thank you, Mr. Chairman.
You're welcome.
Recognizing the time is very short, I'd like to do this rather quick, and if I go too quick, please stop me. Just to get it on the record, the property in question is block 25.02, lot 77, and it has access off of Humbert Place. And that's important because we need a variance for having access off of Humbert Place because it's a private, not a public road. A couple of things are important about Humbert Street. One, it's improved. It's got sidewalk on both sides. It's a short road. The dwelling is only 111 feet or so from the intersection with Humbert Street. It is also relatively level and flat. So I don't think the issues that the municipal land use law raises in section 35 and 36 with issues about private streets really apply here, especially since there is a municipal fire hydrant at the intersection of Humbert Place and Humbert Street. So I think concerns about providing emergency services to a dwelling that's on this property don't really exist in this particular case. The property is small. It's only 2,758 square feet. And that, as an existing property developed with a dwelling, does create some hardships. You've heard we seek to create a two-story addition. I believe it's only about 377 square feet to the per floor. We're also taking down an existing porch on the west side of the property, and that actually means that we're just not adding to the property. We're also removing some of it. Proposed access to the off-street parking basically remains the same. You've heard Mr. Kennedy explain that there are some real-world easement limitations and construction limitations. Why we need to rely on that. As it's mentioned, we're in the R4-B zone. Single-family dwellings are permitted use in this zone, which brings me to my next point. There are two structures on Humbert Place right now that rely on Humbert Place for access. The subject property, a single-family home, and the property immediately to the west of that, which is a duplex, which is obviously a more intense use than a single-family house. The other thing I'd like to point out about that other two-family dwelling, it's been noted that we have practically a dwelling on the north property line. That's not unusual on Humbert Place because the two-family dwelling to the west of us has the same exact configuration. It comes right to the northern property line. We are close to the common property line between the subject property and the two-family dwelling to the west, but so are they. They come to within 0.9 feet, I believe, or they're very similar setbacks. So yes, we are seeking some setbacks, some variances, which are matching the existing dwelling, but they're also consistent with the other developed property on the street. And that also goes to the Humbert Place setback. If you look at the survey done by Harris Surveying, which is a new survey, and by new, I mean it's dated September 10th of last year, it shows the footprint of that dwelling to the west. What it doesn't show is the overhang. And so if you add the overhang, they have even a narrower setback to Humbert Place. So what does all this mean? Unlike the earlier application heard tonight, we do not need a D4 variance. We need a couple of bulk variances. As a lot is somewhat undersized for the zone, that's not surprised. There's also no opportunity on this property to expand the lot size. The property to the west of us, where the two-family dwelling is located, is clearly developed and has no room to provide property to us. The property to the north has a parking lot serving the multifamily dwelling located on Humbert Street, so it has no property to provide. And to the west, to the east of us, the properties fronting the adjacent street are all developed. So there's no adjacent property to be acquired. And I think the lot lines that this lot has are somewhat important. The western lot line, which I spent a lot of time talking about, is just 36.9 feet in length. The front line along Humber Place is less than 68 feet in length. With those kind of dimensions, variances are going to be necessary. And despite these zoning deficiencies, a dwelling with driveway has existed on the property in question for a very long time. And speaking about that dwelling, I would suggest that dwelling is rather old, and some may say there are more attractive properties in Princeton than the current dwelling, and I wouldn't disagree with that. And I think one of the benefits of this application is we replace an older, not attractive dwelling with a new dwelling, which is attractive. I give the architect kudos for coming up with a good plan. So we need some bulk variances. We have two ways of doing that, of course. We can either go C1, which is the physical features test, the narrowness of the lot, the shallowness of the lot, the shape. I've talked about those already. Or we can go the public benefits test, the C2, the more flexible variance approach. In both cases, we have to do the negative criteria, that the variance can be granted without substantial detriment to the public good, and it will not substantially, and that's a real key word because it's in the statute, substantially impair the intents and purposes of the master plan and the zoning ordinance. And turning to the zoning ordinance, the Princeton Planning Board adopted their most recent master plan reexamination report in November of 2023. And there are two, I don't want to go into great detail at 10:55. I never want to talk about a master plan, but there's two things I want to focus on. Under the foundation of the plan, it says one of the foundations of the plan is to maximize the opportunity for every resident to thrive in Princeton. And that could be a good title for this application. We've got an older, not so attractive development dwelling, and what the applicant's seeking to do is to maximize the opportunities to thrive. Under the assumptions of the 2023 plan is the following language, and it's listed as the first assumption, which I believe is important. First was Princeton will welcome new growth. That's stated in your master plan as its first assumption. Well, if Princeton is to honor this stated assumption, I believe a good place for the municipality to start is with this minor addition that doesn't materially change the Humber Place neighborhood. In fact, it materially improves it. So that's the negative criteria. I don't think we substantially impair the intents of the master plan or the zoning ordinance. And because we're not really changing much other than improving the functionality of the dwelling and the appearance of the dwelling, I don't think there's a substantial detriment to the public good. We are adding a bit of a parking area to the east part of the lot. And if you look at the survey I mentioned earlier, it's almost all enclosed with walls and with fencing. And there's also a shed in the back corner. So what that does is that materially minimizes any visual impact by adding a parking area. Under the C2 public benefits test, I think the board can approve this application for a number of reasons. One, and further purposes of the MLUL. And there's several of those. Purpose A, to promote the public health, safety, and general welfare. The proposed use is permitted in the zone. Princeton wants single-family houses on this lot. The applicant furthers Purpose E to promote appropriate population densities. There's a dwelling under existing condition. If this board sees fit to approve the application, there'll be a dwelling under proposed conditions. No change in density. Proposed dwelling expansion promotes Purpose G of the municipal land use law to provide sufficient space in appropriate locations for a variety of uses, including residential. Municipality has zoned this property for single-family dwellings, and one would be both existing and proposed. The application also furthers Purpose L of the MLUL, to promote a desirable visual environment. The expanded and improved dwelling offers neighbors and municipality a significantly improved visual environment. Enlarged dwelling looks substantially better than today's condition. Post-construction dwelling will function at a much greater level. So I think we do provide numerous public benefits. I think there's no substantial detriment to the public good. The property in question now is developed presently. If the application is approved, it will still be just one dwelling on the lot, just one that is more attractive and contemporary. To the west, a two-family dwelling is located. North of the site is a parking lot. I don't believe board's approval of this application will adversely affect either one of them, especially since the two-family dwelling to the west has very similar or identical setbacks to the north, the east, and the south as the proposed dwelling does. The dwelling expansion is towards the east where the lot gains depth. So we're maximizing the benefits of the lot. Existing setbacks are either maintained or become slightly greater as lot becomes deeper. We can accommodate the municipality can accommodate the proposed development while still meeting other zoning standards, most notably FAR, the impervious coverage only increasing by 96 square feet, and by providing for the parking required. Lastly, we also need a section 36, 35 variance from the MLUL. Section 35 states no permit for the erection of any building or structure shall be issued unless the lot abuts a street giving access to such a proposed building or structure, and the street needs to be either a public street or approved by the county. In our case, Humber Place has existed for an extended time, but has never been accepted as a public street. Tax maps do identify Humber Place with the classification of private. Private easements and alleys providing access to dwellings are not unusual in this part of Princeton. There are two which intersect from Jefferson Road, and another private road intersects with Hawthorne Ave. Several more common access ways intersect with Greenview Avenue. That's good from our perspective because emergency service providers have experience providing services to dwellings along these private access ways. Section 36 allows the board to direct the issuance of a permit where the enforcement of Section 35 would entail practical difficulties or unnecessary hardship, or where the circumstances of the case do not require the building or structure to be related to a street. Well, we are related to a street, it's just not a public street, it's a private street. And Section 36 specifically says it can be subject to conditions that will provide adequate access for firefighting equipment, ambulances, and other emergency vehicles. And although Humber Place is not a public street, it is characterized by some of the same attributes. Humber Place features a suitably improved driving surface. Humber Place has sidewalks on both sides of the street. Humber Place is straight, flat, and short, no curves, can easily see Humbert Street from the property in question, and vice versa. And the proposed dwelling is just 111 feet from the intersection. The fire hydrant has been installed at the intersection of Humbert Street and Humbert Place. The traffic generation will be no greater for this single-family dwelling that's proposed as for the single-family dwelling that's on the site today. So that doesn't change. And so for all of these reasons I've gone through in a very short order, Mr. Chairman, I believe the board can grant both the bulk variances, either under or both under the C1 or the C2 basis. I believe the board can find that there's no substantial detriment to the public good or the substantial impairment to the master plan or the zoning ordinances. And I think the board can grant Section 35 relief based on the language that's found in Section 36 of the MLUL, and that based on the attributes of Humber Place and the property in question and the location of the fire hydrant. So for all those reasons, I believe the board can grant this application with the way the plan has been drawn. So I thank you for the board's attention.
Board members, any questions of the planner?
I congratulate him on his quickness of going through all that.
Thank you. I just took a breath.
Okay, Mr. Kennedy. What do you have left this evening? Who else?
That is it, Mr. Chairman. That's our testimony for this evening. So thank you all. I think Steve summed it up quite nicely for everyone. Ultimately, this is improvements to the site that is already a challenging site, a small site. We're not increasing the intensity in any way. We're making improvements to the accessibility, to the visual appearance, and the other elements of the site, while in many cases improving on the existing non-conforming conditions. Thank you.
Thank you. All right. Well, it's after 11. I'm okay if the rest of the board's okay giving it a few more minutes. I can't go too much longer. But at this point, we'll open it up to public comment. Claudia, has anybody indicated they want to speak on behalf of this application?
There's no one on the public.
Okay. I see a hand raised on my screen. Oh, that's my screen. Sorry. Okay. It was my hand. All right. So hearing none, we'll close the public portion of the hearing. And Mr. Kennedy, do you want to say anything else before we go into executive session?
Appreciate the second opportunity, but I'll respect your time and let.
Okay. All right, board members, we're in executive session, so questions, comments, motions?
I like the proposed design. I think it looks nice.
I agree. I think it makes sense.
Definitely an improvement.
Definitely what?
An improvement.
Yes. Any other discussion?
The only thing that I would want to make sure was in any kind of a resolution is the issue of the easement for the private drive. When I went there to look at the property when it was first noticed, it hadn't been plowed, and it was like maybe 3-4 days after the snowstorm. So I think that the easement owner needs to have some responsibilities spelled out.
I believe the zoning memo, the updated one, had a suggestion for us to provide the easements to valid easement to team for their to see. We'd be happy to do that. It is there's a fairly complicated document that governs that, and I'm happy to provide it.
Okay.
I have
Yes.
a question about the what Derek raised about there not being any pins set for the property lines. Does that need to be some kind of condition that needs to be done just to have a actual
Yes, they have to
confirmed?
verify, they have to
Yeah.
verify that the wall is in fact on their property. Yes, I would think it would be. Derek? What do you think?
I mean, there's no room. You could see the rear wall meanders into the public alley. Without pins being set, how does the siding, how is that set back? It's to the siding of the house, so it's pretty close. You have 1.25 inches. It's just not a lot of room. I mean,
You effectively don't know where the property line is relative to the house. It needs to be, you need corner markers. That should
Yeah.
be in the resolution. Any other comments? I think, in my opinion, if this is the way they propose it, it's their call. I think doing a new house it's certainly going to be a lot cheaper than trying to rework what's there and add on to it. That's not going to be cost effective, but that's the way they choose to go. That's fine. So that's my comment. I have no problem with what they're doing now. But, so, any other comments, or would someone like to make a motion?
I would like to move to approve with the conditions that we've already just recently talked about. I guess one is, Mr. Bridger, did you want to say something?
Yeah, the variance for the porch addition in the front should be added as a variance.
Okay.
Appears to be maybe 1.5 feet.
I guess the revision or expansion that it was understood, and that makes sense to us as well. Now that you say it that way.
I guess having proposed the motion, I should be able to collect the various additions that need to happen, but that would be one. To do the survey and know where the property line is precisely.
Set corner monuments so that the corners can be identified.
Okay, what else? What else did we?
Well, the proposed parking now, which is what they did, they changed that. And that turnaround in the driveway.
Anything else?
The easement to Hubbard Place.
So how would we word that? Karen, do you have a?
Yeah, I think we can just take what's in Derek's memo, in which he says a condition should be imposed requiring the applicant to submit a legally valid easement agreement showing access to the subject property for review by municipal staff.
Perfect.
Is that everything?
I think so.
I don't remember anything else.
Second.
Okay, any discussion on the motion before we vote on it? Okay, Claudia, can you please call the roll?
Ms. Chen,
Yes.
Ms. Coulson,
Yes.
Mr. Floyd,
Yes.
Mr. Shriver,
Yes.
Mr. Stein,
Yes.
Ms. Donna,
Yes.
Chairman Cohen.
Yes.
Thank you. It's approved.
Okay,
Thank you all, particularly for the extra time tonight.
you're welcome. All right, so that's it right now. I'm sorry, I gotta leave.
Yeah.
We'll see you all next month.
Good night.
Good night.
Hey.
Night, everybody.